move an application for independent direction in the matter. Now, the basis of by moving this application are certain documents which are placed on record. Not my documents. I have procured these documents by way of RTI from the RBI. These are very essential documents. Not
All right, all right.
No, no, you're not. May I?
All right. All right. Yes. Sir, sir, please wait. We will take up your case at the end. We will take up your case.
I just indicate who I'm appearing for, then my broad points, and then I go quite rapidly.
Yes.
So, Manoj, I'm appearing for a gentleman, Mr. Malvinder Singh. He has filed IA 26757 of 2018. Pursuant to the liberty which was granted by this court on 3rd November 2017. And he had earlier filed a writ petition, but then the court said we dispose of the writ petition and you file an IA, etc. So that's broadly the party I'm appearing for. I might also indicate there are three broad heads of submission. So I'll just mention them to you and then I'll get into the details. So one head of submission, as far as we are concerned, is that there is a violation of the impugned actions insofar as constitutional rights, including fundamental rights, are concerned. We are going to lay our case on the basis of Articles 14, Article 21, and most important also 300A. So this is going to be one set of submissions which we make. The second set of submissions is on the basis of Section 4 of Act 2 of 2017. Act 2 of 2017, which I'll place before you, is an ordinance which was introduced. It replaced an ordinance which was introduced on the 30th of December 2016. I'll place that before you. That particular law extinguished the liability of the Reserve Bank of India under the RBI Act in respect of the specified notes. It also contains a Section 4. And the Section 4, which I will place, allows in certain situations the government, that's the central government, as well as the RBI, to allow the exchange of notes. So broadly speaking, my set of submissions as far as Section 4 is concerned are going to be that there is a power which is coupled with a duty to exercise that power, and the facts and circumstances of my case are such that that power ought to have been exercised. Their failure to do so renders their actions infirm. So that's the second broad head of submissions. The final broad head of submissions is going to be that I'm going to just buttress or endeavor to buttress Mr. Chidambaram's submissions on Section 26(2). So these will be the three broad categories. Now, to just move matters along, I am handing over a list of dates which is specific to me, and I'll just deal with that. And I've requested the court master that on the last occasion, we had handed over two compilations, compilation 1 and compilation 2. So may I just request the court master to identify those in your lordship's papers? They are already tendered. And may I request you to just take up compilation number 1. The title on top, I think, reads IA number 26757 of 2018. Your lordship's have it. Now, I'll just...
57.
Compilation of documents, and the other one compilation of documents on the economic and financial issues.
Because is that correct? That's correct. Economic and financial issues related. That is volume. That is
Compilation of documents.
compilation 1. Now, I'll just indicate how I plan to proceed. I want to first, you have already seen these orders on the previous occasion or the occasion before the previous occasion. I want to just point out 4 orders passed by this court, so your lordship has a sweep. The reason I'm pointing out those orders are, this court has already framed certain questions, so I'd like to place those questions before this court. Thereafter, the act which I mentioned, or the ordinance, came into being. So there was a slight expansion. Obviously, the vires of that act is also at large before this court. So that's the second thing. And the third is 2 or 3 small points which I just want to mention, drawing from this court's order. So please go straight away to the first order, which is at page 1 of compilation, volume 1. I'll just run through these 4 orders quite rapidly. So page 1 is an order of this court dated 16th December 2016. And please see at the foot, we have heard learned counsel for the parties at some length. In our opinion, the following important questions call for our consideration in this batch of petitions. 1. Whether the notification of 8th November 2016 is ultra vires 26(2) and sections 7, 17, 23, 24, 29 and 42 of the RBI Act. Does the notification contravene 300A? Assuming that the notification has been validly issued under the RBI Act, whether it is ultra vires 14 and 19 of the Constitution, whether the limit on withdrawal of cash from funds deposited in the bank has no basis in law and violates 14, 19 and 21, whether the implementation of the impugned notification suffers from procedural and or substantive unreasonableness and therefore violates 14 and 19, and if so, to what effect? In the event that 26(2) is held to permit demonetization, does it suffer from excessive delegation of legislative power, thereby rendering it ultra vires the Constitution? What is the scope of judicial review in matters relating to fiscal and economic policy? Whether a petition by a political party on the issues raised is maintainable under 32, and whether district cooperative banks have been discriminated against by excluding them from accepting deposits and exchanging demonetized notes. Keeping in view the general public importance and the far-reaching implications which the answers to these questions may have, we consider it proper to make the matters to be placed before a larger bench of 5 judges for an authoritative pronouncement. The registry accordingly places the papers before the Chief Justice for constituting an appropriate bench. Well, as far as I am concerned, my primary focus is going to be on questions 1, 2, 3, 4 1, 2, 3, 5 and 6. Now, I will just take you straight away to page 6. Page 6 of the compilation part of the same order, second paragraph. The other broad point was about extending the time limits for exemption for use of demonetized currency notes of 500 and rupees 1000 at specified counters as per the relevant notifications issued by the Reserve Bank of India. It was contended that the exemption period provided in the concerned notifications is expiring. Hence, it will not be possible to deposit the demonetized notes at specified counters thereafter, even in case of emergency situations like hospitalization, travel by railway or air, etc. In our opinion, whether the exemption period should be extended or not must be best left to the judgment of the government of the day, with a hope that the government will be responsive and sensitive to the problems encountered by the common man. Accordingly, we decline to issue any interim direction to the government in the matter of extending the period of exemption and leave it open to the government to take appropriate decisions in that behalf as may be advised. Finally, Your Lordship may just go to page 9, last 4 lines. We further direct that if any other writ petitions or proceedings are pending in any high court, further hearing of those matters shall also remain stayed in terms of this order. We further direct that no other court shall entertain, hear or decide any writ petition proceeding on the issue of with relation to or arising from the decision of the Government of India to demonetize the old notes of rupees 500 and rupees 1000 as the entire issue in relation thereto is pending consideration before this court in the present proceedings. So this was the order of 16th December 2016. 3 learned judges, bench presided over by Chief Justice Thakur at that time, which ends at page 10. Then page 11, Your Lordships may note, is an order of 6th March 2017. 6th March 2017. Now here, there's a couple of things which I'll just read to the court. So there is a set of writ petitions and others which are mentioned in the course title. Please go to paragraph 2. By now, your lordships know that intervening event has occurred, which is the ordinance has come in. I'm just mentioning it. It'll come out in the list of dates, but there is an ordinance now. The court's attention was, I'm reading para 2 on page 11. The court's attention was also drawn to the notification of the Finance Ministry dated 8 November 2016, which envisaged that the old currency notes held by individuals other than a banking company would be permitted to be deposited on specified conditions. Condition number 9 in paragraph 2 postulates as under. Any person is unable to exchange or deposit the specified notes in their bank accounts on or before 30th December 2016 shall be given an opportunity to do so at specified offices of the Reserve Bank of India or such other facility until a later date as may be specified by it. Based on the aforesaid condition, it was submitted that the notification of 8 November 2016 was in consonance with the speech delivered by the Honorable Prime Minister of India on 8 November 2016. The predicament faced by the petitioners emerges from the Ordinance 10 of 2016, issued on 30th December 2016. An extract of paragraph 4 of the aforesaid Ordinance number 10 is reproduced below. Exchange of specified banknotes, 4.1. Notwithstanding anything contained in section 3, the following persons holding specified banknotes on or before the 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank of India or in such other manner as may be specified, namely, 1. A citizen of India who makes a declaration that he was outside India between 9th December to 30th December 2016, subject to such conditions as may be specified by notification by the central government, or 2. Such class of persons and for such reasons as may be specified by notification by the central government. Reliance has been placed in paragraph 5 of the ordinance, and then that paragraph 5 is also reproduced. Based on paragraph 5 extracted above, it was submitted that an avenue had been postulated for dealing with deposits even after the expiry of the grace period, that is after 30th January 2017. It was pointed out that despite the aforesaid postulation, paragraph 5, no individual has been permitted to make deposits of old currency notes after 31st December. It was submitted that the petitioners had genuine reason for not being in a position to deposit the old currency notes by 31st December 2016, and yet no attention was paid to the predicament of the petitioners, even though the petitioners brought out their grievance to the notice of the competent authority, and therefore notice is issued, etc., by this particular bench. Then your lordship may go directly to page 17. Page 17. Now, at this point of time, this is an order of 21st March 2017. 21st March 2017. And it doesn't, nothing much turns on it, but you may just note that my writ petition is shown in the course title at page 17 under the heading item 10. It was 149 of 2017. So my petition was there on that board, and nothing much turns on this. Now our bench is, as I mentioned, presided over by Chief Justice Kehar. Please go directly to page 19. So even in my writ petition 149 of 2017, just that order, issue notice asking so-and-so accept notice. Now look at para 3. I think this is of importance. Having heard submissions which remained inconclusive, and before proceeding further with the matter, it was felt that this court should ascertain from the Union of India, A, whether the central government intends to exercise its power conferred by clause 412 of Ordinance 10 of 2016, and B, if the answer to A is in the negative, the reason why the central government chose not to exercise its jurisdiction. An affidavit may accordingly be filed by the central government explaining its position to the court. So this, I will develop the point, but this is that power coupled with duty argument which I had indicated to the court. You may consider just noting here that the government did file an affidavit. It is at pages 88 to 100 of this very compilation. So you may just note it over here. And they politely declined, and they said, sorry, we are not in a position to do that. You may recall, and I'll come to, when I come to my list of dates, that the assurance given initially by the assurance meaning the speech of the Prime Minister, which I think is entitled to a great degree of respect. had indicated that the time would be extended. The Reserve Bank of India initially also said that it will extend in appropriate cases beyond 31st December 2016. Then Parliament brings in this ordinance where they have this power, but just see the affidavit at page 88 and then I can be done with that. The affidavit begins at page 88, same compilation. Short affidavit on behalf of respondent number 1, that is Union of India through the Secretary, Ministry of Finance. And please go to paragraph 7 on page 90. So they refer to clauses of the ordinance, grace period, and see the last 3 lines in para 7. There is no legal duty case upon the government to issue any notification extending the grace period. Equally, the petitioner has no legal right to claim a grace period. And then you may just, then there are various justifications which are proffered. And I'll just be done with this affidavit. Just allow me to go back and forth. Please go to page 99 for a minute and then I'll just read a couple of paragraphs earlier. Just see para 26, because this is in response to the directions of this court. So para 26 says, in view of the above, and those to be urged at the time of the hearing, it is most humbly submitted that the central government took a conscious decision that no necessity or justifiable reason exists, either in law or on facts, to invoke the power under 412 of the ordinance to entitle any person to tender within the grace period the specified bank notes. So the whole purpose, the object was that there are people who may be hospitalized, there may be people who are overseas, etc., etc. We'll come to that. But the the affidavit was rejected this particular request and so answered the issue is on affidavit on behalf of the government at an early date. Then please go to the last of the orders that I want to read, which begins at page 20 of the same compilation. Now, this is 3rd November 2017. This is a bench which is presided over by Chief Justice Deepak Mishra. The order begins at page 20. You may go directly to page 22. In the second line, with regard to all those petitions which are enumerated, you will find my writ petition there, 149 of 2017. Now, I'll just quickly read. Having heard the learned counsel for the petitioners, Attorney General for Union of India, we think it appropriate that the petitioners should file applications for intervention and impleadment in writ petition civil 906 of 2016 titled Vivek Narayan Sharma versus Union of India. It is hereby made clear that they can assist the court when the matter is argued with regard to, now mark the next few words, with regard to the constitutional validity of the law. So there were those original questions which were there, those questions which Justice Thakur had framed, but that time there was no ordinance, though 26(2) etc. is mentioned. And now we have an ordinance and then we have a law. So now this comes in over here, assist the court when the matter is argued with regard to the constitutional validity of the law. That apart, their individual grievances is also important for my purpose. That apart, their individual grievances may be dealt with by the Constitution bench, keeping in view the ultimate decision of the larger bench, or if it is otherwise possible, the instant petitions are accordingly disposed of. All pending interlocutory applications are disposed of. Then I might just mention the last part. I'll just read it. Under 169 of 2017, it is submitted. The learned counsel, Mr. Jain, learned counsel for the petitioners, that writ petition has become infructuous. It's accordingly disposed of. When we say that the writ petition has become infructuous, it has to be made clear that the court has not expressed any opinion on the merits of the list because those other matters were pending. Now, you should just note, I mean, it's only historical. This set of petitions was dealing with cooperative banks because the cooperative banks had a grievance at that point of time that, look, we are not being allowed to deposit, exchange our notes, etc. That issue was addressed by an appropriate order, notification, etc. on 20th June 2017, made or issued under Section 4, the very section which I'm going to endeavor to persuade your lordship, they should exercise the power in my favor as well. But they did it for cooperative banks. So this whole matter now has ended. Now with that, my lords, I'm done with the orders. I'm grateful. Now we've handed in a list of dates. So would your lordship just go through the list of dates? Now here, my lords, what I'm planning to save, in order to save time, I'll just indicate what I'm, sorry. I was just suggesting that instead of reading the whole list of dates, since there are mostly statutory notifications and statutes, etc., I will read along with I'll go straight away to the document itself so that we don't have to visit it twice. Now, broadly, let me just tell you the facts of my case in a nutshell. On 11th April, the applicant, the party I represent, Mr. Malvinder Singh, is a senior citizen. He's around 78 years of age now. Now, his son is based in the United States of America. And as is not uncommon, and it's a value which is greatly respected by this court, etc., and an aspect of dignity, familial bonds, etc., people visit their children overseas. There is care, there are connections which are restored, and that's how relationships are maintained. Your lordships have recognized over the years the right to travel abroad. So anyway, I exercised that right, not that anyone was stopping me, and I went abroad. I went abroad on 11th of April 2016. The announcement, as your lordship recalls, came on 8th of November 2016. At that time when the announcement came, there was an assurance which was made by the Prime Minister, and it was followed by Reserve Bank of India assurance also, that look, 30th December 2016 is the deadline. But that will be extendable in the sense that at Reserve Bank of India designated branches, even after that deadline, you will be able to exchange your notes. Now, he had withdrawn and had in his custody, this is a little important for our facts, he had withdrawn and had a total of 1,62,000 rupees, which he had placed in his home in India. He's an Indian citizen. When he went abroad. At that point of time, they were contemplating a knee surgery. Fortunately for us, or fortunately for him, there was alternative treatment, etc. And the surgery, for the knee surgery was not required, though there were certain other surgeries which were required as far as he's concerned. But he didn't have to go through with the knee surgery. He returned to India on the 3rd of February 2017. I'm just giving you a broad picture. So 3rd February 2017, he returns. Now, by this time, that ordinance has come into place. The moment he returns, he tries to exchange that 1,62,000, which is lying with him in the old currency notes. He writes letters, communications, those representations are there. The application comes to be rejected. Now he finds himself in a bind, and I'll just broadly indicate what the problem is. The problem is, first, he has come back after 31st December 2016. So that assurance which was extended by the Prime Minister and the Reserve Bank of India in the first instance has suddenly, according to the respondents, been overtaken or stands diminished or virtually eroded, let me say, eroded by a statute in the form of an ordinance, later on replaced as Act 2 of 2017. And what does that ordinance say? That ordinance, in a nutshell, says that, look, there is a hard stop. The hard stop is ordinance issued on 30th December of 2016. 24 hours later, 31st of December 2017, after that, you cannot exchange notes. I'm just going very broadly. Of course, there are some narrow exceptions. So this is the first time where there is a hard stop introduced by way of a law with just a 24-hour window. Ordinance on 30th December, no exchange allowed after 31st of December. Then it says something interesting. It says that, look, if you are, now this is an exercise of powers under Section 4, etc. What they've said is that if you have left the country, just broadly indicate, if you have left the country, we have a law called FEMA, which your lordships are familiar with, Foreign Exchange Management Act. Now it allows you to carry currency outside India. FEMA allows you to export a certain quantity of Indian currency. When you are coming back into the country, FEMA also contemplates, if you are carrying such currency, to make a declaration. So what they have said is, under Section 4, that if you, up to that limit which FEMA recognizes, and on return to India, when you came back to India, if you made a customs declaration that, look, I am coming back to India with that declaration of those many notes under the limit, then we will exchange your notes. So what you will find in the law is that the effect is that people like me, who are Indians, who had kept their money in India, I didn't take it abroad. There was no question of FEMA applying to me. I have my house and residence in India. I left my money over here in India. I came back, as I indicated, on the 3rd of February 2017, and I found that I was absolutely without any recourse. So this money had been rendered completely naught, unless we are able to persuade your lordships otherwise. So the scheme, what I'm indicating is the scheme doesn't capture me or contemplate a situation of individuals like me at all, who were abroad, who returned after the 31st of December 2016, and who had money in India, lawfully kept money in India. This is the broad background. This is the problem which I'm facing. And therefore, our respectful submission is, of course, we support all the submissions which were made yesterday, because naturally the consequence of striking down that action will be, there would be relief which would come to at least persons like me who've come before the court. That's one element. The second element is that even if we are able to eventually persuade your lordships with regard to the RBI, I will call them the RBI points, which means 26(2) and all those points, we hope to persuade your lordships that, look, there appears to at least us, on our understanding, to be a constitutional right under 300A. And when that is read with 21 and 14, situations like mine ought to be covered before you take away or extinguish someone's property. There has to be recourse. You can't take away my property. This is the most basic element, I mean, currency notes. So this is going to be my broad, respectful submission. If we can find a way out under Section 4, nothing like it. This is the broad fact. Now, may I go to the list of dates? I'm sorry, a very long introduction.
The money is still with you?
Yes, the money is still with me. And when we go to the list of dates, I should just mention that there was a protective statement which was made by the Attorney General. It's not recorded in any of the court's orders which I have recorded, but there are contemporaneous news reports. Because the issue was that people who were in court and had that money, they were liable to prosecution, correct? Because under the Act, that was the scheme of the law. So a statement was made that, no, we will not, as far as parties who are here before the court are concerned, we will not take such action. So for me, fortunately, that hasn't happened. I have no complaint on that score. But that's just to complete the picture. So this is the background. Now, may I request your lordships have the list of dates? So we begin on 3rd December 2015. Mr. Malvinder Singh, a senior citizen and an NRI, withdrew an amount of rupees 1,20,000 from his bank account in the Central Cooperative Bank, Sangrur, Punjab, branch so-and-so, and kept the amount along with earlier savings of rupees 42,000 in cash. The amount was saved in anticipation of a knee operation. Thus, a total of rupees 1,62,000 The entire cash is held in 500 and 1000 rupee banknotes. We have given you the details of how it adds up. 132 notes of 1000, 60 notes of rupees 500. We've given you the breakup. March 2016. By March 2016, the currency notes in denominations of rupees 500 and rupees 1000 constituted 47.8% and 38.6% of the currency in circulation. In aggregate, this is 86.4% of the total currency in circulation. So this is a little earlier, March 2016. Now, my lord, since your lordships have volume 1, may I just indicate, how this list of dates of mine works. So just please go to page 1 of compilation volume 2, just for a moment, so that we know how the referencing is done. So you will have, this is the Reserve Bank of India report itself. It's called the annual report for 27-2018. It begins at page 1. Your lordships have that on volume 2. And please go to page 2. On the right-hand column, you will find table 8.1. Your lordships have table 8.1. My lords, compilation volume 2. Oh, sorry. It's called compilation of documents on behalf of the applicant on the economic and financial issues.
The economic and.
My lords, sorry.
That is volume 2.
No.
I'm going to request you to please mark Roman 2 on it, because my list of dates mentions Roman 2.
Yes,
Okay.
right.
You are referring to annual report.
Yes, annual.
Annual report 2017-28.
Absolutely right.
There is no volume number, etc.
Yes, so may I just, sorry, my mistake. I had it on my copy, so when the list of dates was prepared, it was marked as 2.
Assisting, lawyers are more considerate towards you and not towards you.
So now we'll call this volume 1,
Accepted.
the other one volume 2.
Yeah, may I just request that this may be just marked 2. Thank you very much. So page 1 is the annual report of Reserve Bank of India. So just one thing which you have to see on page 2, there's a table 8.1, banknotes in circulation. Your lordships have that. And as against March 2016, you will find 2 figures, my lords, against 500, you will find 47.8 in brackets. And against under 1000, you will find in brackets 38.6. So when you add up both 47.8 plus 38.6, you arrive at 86.4. So that's where the figure of 86.4% being the amount of currency in circulation figure which we get. Then returning to my list of dates.
No, that is the value in billion.
Yes, that's the percentage, my lords.
That is not the volume.
The percentage of the value in
Even below.
in rupees billion.
It is in,
Just see the note. Figures in parentheses represent the percentage share in total volume value. Your lordship has that? So therefore, we have added 47.8% and 38.6%. And therefore, the percentage in value comes to 86.4% of the total currency in circulation. Enormous. Now, returning to my list of dates. 11th April 2016, Mr. Singh and his wife traveled to the United States to meet their son, who's residing there. The savings of rupees 1,62,000 were kept in their home in Sangrur during this visit to the United States. Now, I won't take you to these, but we have given you the passport pages which give you the exit date, etc. But I won't take you to that. Now, my lords, 8th of November. So lots of things happened on 8th of November 2016. May I take you to the compilation so that your lordships will not have to read the list of dates. So please go now. We are on volume 1 of the compilation. And please just have a look. Go straight away. Your lordships may go to page 24. Well, this is going to be a very important plank for my submission. Well, this is the Prime Minister of India making a very, very important policy announcement. It contains certain assurances and representations. In my respectful submission, any measure of reasonable conduct, this ought to provide a suitable base benchmark. It is not for the government to say and the respondents to now say that no, we will ignore what was stated in this particular address to the nation. So I am using it at 2. I mean, technically they may be right. Obviously, there's no estoppel against some legislature and all that. Nobody is suggesting that. But I'm saying as a benchmark of reasonableness, as a benchmark of fairness, because I think the Prime Minister's speech is reasonable and fair with regard to this issue of exchange of notes is concerned. And now to depart from it and to deprive someone like me, according to me, if we are right, is probably improper on the part of the respondents. So the speech itself begins on 8 November 2016 at page 24. Your Lordship may go straight away to the foot of page 26. There is an enumeration there. The steps will strengthen the hands of the common man in the fight against corruption, black money, and fake currency. Sorry, it begins at page 24.
Yes.
Compilation 1. Okay. Your Lordship has page 26. So, now I'm taking advantage of, improper advantage of Justice Gawai's question and reading from one paragraph earlier. So, just brothers and sisters, about 10 lines from the bottom, Your Lordship said. Brothers and sisters, to break the grip of corruption and black money, we have decided that 500 rupees and 1000 rupee currency notes presently in use will no longer be legal tender from midnight to night. That is the 8th of November 2016. This means that these notes will not be acceptable for transactions from midnight onwards. The 500 and 1000 rupee notes hoarded by anti-national and anti-social elements will become just worthless pieces of paper. The right and interests of honest, hardworking people will be fully protected. Let me assure you that the notes of 100, 50, 20, 10, 5, 2 and 1 rupee and all coins will remain legal tender and will not be affected. This step will strengthen the hands of the common man in the fight against corruption, black money and fake currency. To minimize the difficulties of citizens in the coming days, several steps are being taken. 1. Persons holding old notes of 500 and 1000 rupees can deposit these notes in their bank or post office accounts from the 10th of November till close of banking hours on 30th November 2016 without any limit. Thus, you will have 50 days to deposit the notes and there is no need for panic. Now, let's see number 3, please. Your money will remain yours. You need have no worry on this point. This is very, very important, Balot. Very, very important and very fair and very correct. Please go to paragraph 9. Several assurances extended. Para 9. There may be some who, for some reason, are not able to deposit their old 500 and 1000 rupee notes by 30th December 2016. 10. They can go to specified offices of the Reserve Bank of India up to 31st March 2017 and deposit the notes after submitting a declaration form. Now, this is a very solemn, fair declaration. So at least I of course, arrived well before, I arrived in February. So well before 31st March 2017. This is now the assurance which is held out across to the people of India. And I believe it is entitled to the highest degree of respect. Then please go, yes, so I'm done with these points 9 and 10. Since we are on the compilation, please go to page 31 at 33. So this is again on the same date, 8 November 2016. Your Lordships have a statutory notification?
Yes.
This was referred to by Mr. Chidambaram from another compilation itself. So here, Manoj, I'm just emphasizing 2 or 3 points. I'll just read the recitals and then one clause. Whereas the Central Board of Directors of the Reserve Bank, hereinafter referred to as the board, has recommended that bank notes of denominations of the existing series of value of 500 rupees and 1000 rupees, hereinafter referred to as specified bank notes, shall be ceased to be legal tender. And then they talk about the problem of fake currency. The next recital talks about high denomination banknotes used for storage of unaccounted wealth. Further recital makes a reference to subversive activities such as drug trafficking and terrorism, causing damage to the economy and security of the country. Now, therefore, in exercise of section 26(2), to the extent specified below, namely, the central government hereby declares that the specified banknotes shall cease to be legal tender with effect from 9th of November to the extent specified below, namely. Now, in these various conditions, please go to clause 9 for my purposes, page 34. Any person who is unable to exchange or deposit the specified bank notes in the bank accounts on or before the 30th of December 2016 shall be given an opportunity to do at specified offices of Reserve Bank of India or such other facility until a later date as may be specified by it. So again, this is now a statutory notification under 26(2). Your Lordship sees at this point of time, I'm in the United States. And all right, I have plans, etc. to return. This is completely consistent. I would say that this is completely consistent with the assurance which was extended by the Prime Minister in his address to the nation. So there's no problem with this either. So at specified banks or branches of offices of Reserve Bank of India, even after 30th of December 2016, there ought not to be any problem on this issue. Sorry? Yes. Now please go to page 35. Page 35. Now this is again same date, 8th of November 2016, and this is the Press Information Bureau. Here again, there are just two clauses that I want to highlight. After mentioning, my lords, the ills which are sought to be addressed, counterfeit note, your lordship, the subversive activities, espionage, smuggling of arms, drugs, contrabands into India, etc., eliminating black money. Now please see paragraph 4. In the last 2 years, the government has taken a number of steps to curb the menace of black money in the economy, including setting up of special investigation team, enacting a law regarding undisclosed foreign income and assets, amending the double taxation avoidance agreement between India and Mauritius and India and Cyprus, reaching the understanding with Switzerland for getting information of bank accounts held by Indians with HSBC, encouraging the use of non-cash and digital payments, amending the Benami Transaction Act, and implementing the income declaration scheme of 2016. And now please go overleaf to clause 10. And in para 5 opening words at page 35, they say the following operational guidelines have been issued. Operational guideline number 10 at page 36 reads, for those who are unable to exchange the old high denomination banknotes or deposit the same in their bank accounts on or before December 30th, 2016, an opportunity will be given to them. Will be given to them to do so at specified offices of the Reserve Bank of India on later dates, along with necessary documentation as may be specified by the Reserve Bank of India. So it's broadly unconditional. Of course, you have to proceed certain documents, etc. But broadly, at least the representation made at this point of time is also based on is sort of that you can, that 30th December 2016 or 31st December is not going to be a hard stop. Now please go to yet another Reserve Bank of India press release at page 37. Page 37. Same date, 8 November 2016. Page 37. And here I invite attention to the second last paragraph on that page. Any person who is unable to exchange or deposit the specified banknotes in their bank accounts on or before December 30th, 2016 shall be given an opportunity to do so at specified offices of the Reserve Bank or such other facility until a later date as may be specified by the Reserve Bank. So everyone is speaking in one voice, and I think this is a very, very reasonable representation made. Prime Minister, Government Bureau, Finance Ministry notification, Press Bureau, Reserve Bank of India press release. So and therefore, I don't think that response to the short affidavit, which I just referred to, where they said, no, we are not going to consider this under section 4 of the ordinance, paras doesn't appear, at least according to us, to be justified. Now, Your Lordship need not turn to the list of dates, but I'll just read the item. I'll just read the items, or you may follow it, the list of dates. I'm not going to read very much till the next statutory document. Foot of page 3, November 16, Several writ petitions were filed challenging the policy of demonetization before various high courts and the Supreme Court. Transfer petitions were filed by the union seeking transfer of all the matters pending before the high courts to the Supreme Court. Then the 16th December 2016 order bench presided over by Justice Thakur I've already read, so I'm going to skip that item. Then please go to 30th December 2016. Now this becomes important because this was not placed in the sense it may have been referred to yesterday, but it wasn't as such placed. So this becomes very important development on 30th December 2016. Let us go to page 38 of the compilation volume 1. Now let me just state the point here. Our focus yesterday was on section 26 when Mr. Chidambaram was arguing it. May I, with your permission, just take you for a moment to section 34 of the RBI Act. Just for a moment, let us just take up section 34. I'll come back to this, but your Lordship may just cite it for a moment. Yeah. P4. Your Lordships have it? 34. So this is the focus now. Please see liabilities of the issue department. Your Lordship went through the scheme of the issue department, etc. Now look at 34. The liabilities of the issue department shall be an amount equal to the total of the amount of currency notes of the Government of India and bank notes for the time being in circulation. So this is an independent liability created under statute under 34. So two obligations, apart from their sole power to issue notes, etc. Look at 26(1). Subject to the provisions of subsection 2, every banknote shall be legal tender at the place in India in payment or on account of the amount expressed therein and shall be guaranteed by the central government. So guarantee of the central government is one legal concept. Liability of the Reserve Bank of India issue department is a second legal concept. We'll come to it. But the reason I'm flagging it is that this ordinance seeks to...
I didn't get it.
Sorry.
I didn't get your submission.
Yes. Sorry, Manoj, I'm just pointing out very briefly at this point because I'm going to take you to the ordinance. And just in anticipation of what does the ordinance do, I'm just explaining what it does. What it does is it extinguishes two statutory obligations. So conceptually under the Reserve Bank of India Act, we saw that yesterday, there is an exclusive authority or power to issue notes that your Lordship saw yesterday. Only the Reserve Bank of India. That's for global concerns, Manoj. You are managing this type of an economy, huge economy, complexities, etc. People to have confidence in the system, you create a separate Reserve Bank and you confer that authority on the Reserve Bank of India. So that's one aspect. Now, how does that particular currency note which is in circulation, how does it have, how is it honored? And how does it gain, in a manner of speaking, currency or confidence in the public? The confidence comes to the public as a medium of exchange. So store of value is one element. Medium of exchange. That comes from what? It comes from two legal obligations which the Act itself imposes. One on the Government of India and the other on the Reserve Bank of India. Now what are those? 26(1) is guaranteed by the central government. Your Lordship has seen that. So that, Justice Gawai.
Yes.
Guaranteed by the central government. So, I mean, the entire sovereignty, integrity of the nation backs this particular note which is issued in terms of this Act. That's one, the central government, highest authority in our country. Then there is a further independent obligation because, I mean, private banks or, I mean, by private banks, I mean non-Reserve Bank of India, whether it's nationalized or otherwise, have in the old days, your Lordship recall, they used to issue their currency notes as well. But now that is all abolished and there's an embargo on that. Then whose liability will it be? So the liabilities of the issuance department of the Reserve Bank, please see section 34. So guarantee, but who has to pay? The payment in the first instance is in terms by the issuance department. Liabilities of the issue department shall be an amount equal to the total amount of currency, notes of the Government of India and banknotes for the time being in circulation. This is sought to be now extinguished, as we will see from the ordinance. So that was just the background. Now let us see what the ordinance does. So first, if you now compilation 1, page 38. So please see, this is titled the Specified Banknotes Cessation of Liabilities Ordinance 2016. Please note the date 30th December 2016. Your lordships have that? 30th December 2016, this is issued. And when we go further down, you will find it comes into force straight away on the appointed date is 31st December 16. I'll come to that. Now let us see, my lords, the recitals. An ordinance to provide for the cessation of liabilities on the specified banknotes and for matters connected therewith and incidental thereto. Whereas the central government, on the recommendations of the central board, with a notification of 8 November, declared that the then existing series of banknotes of the denominational value of 500 rupees and 1000 rupees ceased to be legal tender from 9th November 16. Whereas a part of the series of banknotes in circulation which have ceased to be legal tender on account of the said notification has come back to the Reserve Bank of India. Whereas such banknotes which have ceased to be legal tender are a liability on the books of account. I think it should be account, it can't be accounts. In the books of account of the Reserve Bank of India under section 34 of the Reserve Bank of India Act 1934. And whereas it is necessary to have clarity and finality to the liabilities of the Reserve Bank of India and the central government arising from such bank notes which have ceased to be legal tender on the basis of the said notifications, and whereas Parliament is not in session and the President is satisfied that the circumstances exist which render it necessary for him to take immediate action. Now, therefore, in exercise Article 123, the ordinance, it shall come into force on 31st day of December 2016. In the said ordinance, unless the context otherwise requires, appointed date is 31st December 2016. Then you have a statutory definition of grace period, means the period to be specified by the central government by notification, during which the specified banknotes can be deposited in accordance with the ordinance. Notification means a notification published in the official gazette. Reserve Bank specified banknote are the 500 and 1000 rupee notes of the series existing on or before 8th of November 2016. Now please see section 3. So section 3 is important for our purposes. The marginal note, specified bank notes to cease to be liability of the Reserve Bank or central government. On and from the appointed day, notwithstanding anything contained in the RBI Act or any other law for the time being in force, the specified bank notes which have ceased to be legal tender in view of the notification of the Government of India dated 8 November 2016 issued under section 26(2) of the RBI Act shall cease to be liabilities of the Reserve Bank under section 34 and shall cease to have the guarantee of the central government under subsection 1 of section 26 of the Act. So this is the statutory. Now look at section 4, which we will focus on, but I'll read through it. Exchange of specified banknotes. Section 4.1. Notwithstanding anything contained in 3. So it's a non-obstant clause. It overrides 3. Of the following persons holding specified banknotes on or before the 8th day of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank or in such manner as may be specified by it, namely, 1. A citizen of India who makes a declaration that he was outside India between 9th November 16 and 30th December 16, subject to the conditions as may be specified by the notification by the central government, or 2, such class of persons and for such reasons as may be specified by notification by the central government. So there is a power. We'll come to that. But there seems to be a power for grace period. Now look at subsection 2. The Reserve Bank may, if satisfied, after making such verifications as it may consider necessary that the reasons for failure to deposit the notes within the period specified in the notification referred to in section 3 are genuine, credit the value of the notes in his know your customer compliant bank account in such manner as may be specified by it. So there's an overarching power under 4. There's a power as we read it under 4.1 as well as 4.2, at least on our reading of it. And 4.3, any person aggrieved by the refusal of the Reserve Bank to credit the value of the notes in subsection 2 may make a representation to the Central Board of the Reserve Bank within 14 days of communication of such refusal to him. An explanation, your lordship may just know, mine is a know your customer compliant bank account. For the purpose of this section, the expression know your customer compliant bank account means an account which complies with the conditions specified in the regulations made by the Reserve Bank under the Banking Regulations Act 49. Then section 5 is prohibition on holding, transferring or receiving specified banknotes. Penalty for contravention of section 4 is section 6. Penalty for contravention of section 5 is section 7. Offences by companies. Special provisions relating to offences is section 9. 10. Protection of actions taken in good faith, power to make rules, power to remove difficulties. And just for completeness on this aspect, you may note, I will stick to my list of dates, stick to the sequence, but just for cross-reference, you may note that the Act in the same terms is at page 53 of this paper book. It is Act number 2 of 2017. So that's now the provisions which are actually extant and which are in force. So this is what replaced the ordinance. It begins at page 53. It runs all the way up to page 56. Now, sorry. Now, may I go back to the
No
comment?
change, there is no change.
There's no change. There's no change.
You
It's in-
not refer to the act in your list of dates?
Yes, I have referred to the Act. It will come. Sorry, I should indicate where that comes. Bottom of page 7.
Yes.
Your Lordships have an item 27th February 2017.
Yes.
Yes. So may I continue?
Yes.
So please go now to the an event which occurred on the same day, page 44 of the compilation. This is 30th December 2016. In exercise of powers conferred by clause B of subsection 1 of section 2, read with clause 1 of subsection 1 of section 4 of the ordinance, the central government hereby specifies, in respect of citizens of India referred to in clause 1 of subsection 1 of section 4 of the said ordinance, A, who is a resident in India, the period ending on 31st day of March 2017. So this is the grace period. This will not affect me because it is for a person who's resident in India. So this will not, I'm just mentioning it in the facts of my case. Then B, who is not resident in India, the period ending with 30th June 2017. So I may be covered by this, but we will see as to how it operates as the grace period for the purposes of the said ordinance. Correct?
Resident or non-resident, as on what date?
That's period ending is given. Oh, I'm sorry. Grace period. I'll just examine that and come back to your lordships on this. No, the act says so.
Does the act or ordinance?
The ordinance says so.
As on.
You're absolutely right.
Suppose they have gone out just the previous day for a 6 months tour.
Correct. We'll just examine that and come
First
back.
week of November if they have gone.
As on what date? NRI, I don't know. I recall reading it, but I'll try and just come back. Now let's please see the proviso. That's of relevance. The proviso at page 44. This is right at the end of the grace period for the purpose of the said ordinance. Provided that the amount of specified banknotes tendered does not exceed the amount specified under Regulation 3 or Regulation 8 of the FEMA Export and Import of Currency Regulations 2015 made under the provisions of FEMA and the conditions specified therein are complied with. Can I just explain the effect of it? What this says is that provided the amount of the specified notes does not exceed the amount, what they are doing therefore by this proviso is they are extending the grace period only to people who had taken money out and brought money back in and made that declaration. That will become clear from the next notifications, etc., which I read. I hope I've made. So there is a grace period which is extended. The grace period is 31st March 2017 for those resident in India. And if you are not resident in India, it is a period ending on 30th of June 2017. Correct? But what's the proviso? The proviso says that this FEMA requirement cannot be exceeded. So 2 or 3 problems. So this will apply only. Yes.
It will be applicable to all persons who are outside India between 9th November 2016 to 30th of December 2016.
Yes.
Yes. And the grace period distinguishes, insofar as Indian residents are concerned, it will be up to 31st of March 2017. And insofar as NRIs are concerned, it will be up to 30th of June 2017.
Absolutely right. Now see the proviso. But I think there's no, I think on that aspect, I would agree with what the, but see the proviso. Provided, I'm on page 44.
Yes, yeah.
Provided that the amount, so there's a cap, the amount of specified banknotes tendered does not exceed the amount specified under Regulation 3 or Regulation 8 of the FEMA export regulations dated made under the provisions of FEMA and conditions specified therein are complied with. So there is a cap. And what is this cap in respect of? I asked myself. This cap is in respect of what you could export out of India and what you could bring back in India. So I mentioned there are 2 situations. There are situations where someone like me, which is my case, has left the currency in India.
So according to what is given to you by the substantive provision, is being taken by where provided.
Well, could have been given to me. You're right. Absolutely right. The conditions imposed by the proviso, because of the proviso, exclude operation of this notification to a person like me entirely. Entirely. An Indian who has gone out and who had left his money in India, whether he be an NRI or a resident of India, but returned after 31st of December 2016, is completely out. Completely out. The question I ask myself is, and we'll see that the grace period is then given in the next document. So,
4.1, 4 section.
yes, 4.
Because 4.1 relates to only persons who have gone out of India.
Yes,
But this clause A in the notification,
yes,
it speaks of a person who is resident in India.
yes.
A person who is resident in India, that cannot be related to 4.1 at all. Because that is a person who has gone out.
No, so sorry. So resident, Manoj, as I
You have to
understand it,
understand what is the meaning of because resident and who is, if he is resident in India,
yes.
he is not a person who has gone outside in India.
So sorry.
Between the 2 period.
So I'll just, I'll from the income tax.
Now, even for a resident in India, this proviso applies. Even if he has not gone out.
Yes. So,
Means he was in India, or does it mean resident, non-resident as?
yes, it means resident and non-resident.
As
NRI you have a notion, you
As
have
per
an
Income Tax Act.
under the Income Tax Act. So I think my preliminary response would be resident or NRI in that financial year, because we are going on the basis of a financial year. So there is that benchmark of 182 days, etc., which applies to determine whether you are resident in India or whether you are a non-resident Indian. So the way I would reckon, so I'm sorry, I'm repeating myself. The way I see it, the way I see this operating, now I'm on the notification, is that yes, it does define a grace period. However, the proviso operates in such a manner, which is not fully fleshed out from reading this notification. I have to read one further document and it will become clear. The proviso takes people like me who had left money in India completely out of the purview of any benefit of grace period. And that is how it is operating, and that is how they understand it to operate. And therefore, my application has been rejected. Even though I had withdrawn money from the bank, I had kept it in India. I can explain the entire amount. But I came back in February. That's all. There is no grace period for me at all on its working. Now, it may become a little clearer from the next document, page 45. Just let us see page 45, same. See now what the RBI says, and I think it will become clear from here what they mean by resident, non-resident, etc. Your Lordships have the circular, which is issued by the RBI on 31st December 2016. So this is again during the ordinance. Facility for exchange of specified bank notes during the grace period, verification of KYC account details, etc. Please refer to the Government of India. This is notes to all the chairmen of various banks, cooperative banks, etc. Please refer to the Government of India ordinance dated 30th December 2016 on the specified bank note cessation of liabilities. In terms of para 4.1, the above facility, the exchange of specified bank notes is made available for resident and non-resident citizens who could not avail the facility from November 10th to 30th December 2016 on account of their absence from India during this period. In particular, the above facility is available only to those tenderers whose accounts are KYC compliant and who have not deposited SBNs into the amounts from 30th November to December 30th. As the above information is available with banks, specific offices of RBI will be approaching the banks for number one, confirming KYC status, and two, information on deposits of SBNs, if any, into the accounts of the tenderers. The banks are therefore advised to put in place an arrangement to furnish the required information within 7 days from the date of receipt of this request. Towards this, the banks may designate an officer at the rank of the general manager as a nodal officer and may be conducted by the office. The name, contacts, etc. Please acknowledge receipt. Now see the next page. Page 46. Facility for exchange of SBNs during grace period. In terms of 4.1 of the Ordinance 2016 and notification of December 30th, 2016 thereunder, the caption facility has been formulated by the Reserve Bank of India to afford an opportunity to those Indian citizens who could not avail the facility of exchange of SBNs under the earlier facility, and they are not present in the country during the period November 9th to 30th December 2016. Places of exchange, eligible persons are given, are indicated, etc. Now please see resident Indians. So only those, on top of page 47, only those residents who were abroad during the period November 6th to 30th December 2016 will be eligible to avail the facility only once during the tenure of the facility. There will be no monetary limit for submission of SBNs in the tender. So this is important because it's a measure of reasonableness. They realize that if you are qualifying, etc., no monetary limit for submission of SBNs in the tender. Then these are, of course, residents in India. Tenderers should be submitted in tender form as per Annexure 1. A copy of the passport with the immigration stamp, etc., should be given. Now, please see B, NRI. This covers me. This covers me because I was non-resident given the number of days I had spent. Only those NRIs who were not present in India during the period November 9th to December 30th will be eligible to avail this facility once during the tenure of the facility. Tenderers should be submitted along with tender form 2. Now see this. Tenders will be restricted to a maximum of 25,000 rupees per individual, depending on when notes were taken out of India as per the relevant FEMA rules. A copy of the passport with immigration stamp as proof of the individual's absence from the country during the period. Passport in original should be presented at the RBI counter for verification. Now please see next item 5. A certificate issued by Indian Customs on arrival through Red Channel after December 30th, 2016, indicating the import of SPNs with details and value thereof should also be submitted. Copies of statement of all bank accounts evidencing that no SBNs were deposited during so-and-so period. Requisite documents as per the provisions of 114B of the income tax rules. An acknowledgement of receipt will be issued to the tenderers pending credit of the admissible amount. 9. On ascertaining that the tenderer was abroad during the period from November 9 to December 30th, the account is KYC compliant. Fulfillment of other conditions and genuineness of the notes tendered admissible amount will be credited to the amount under the advice of the tenderer. And then the duration is given. The facility will remain open from 2nd January to 31st March and for NRIs up till 30th June. Representation, any person, etc., aggrieved, etc., may be this thing. Then the tender form is Annexure 1, which is at page 49. Your Lordships will find. Yes.
One question, please.
Yes, of course.
Are you a NRI or a resident Indian who has gone abroad? You belong to which category?
All right. So I just tell you,
Are you a NRI?
So
No.
first I'll answer the question. Am a NRI?
You are a NRI?
Yes. Now the concept of NRI is dependent upon the number of days you are in India or conversely the number of days which you are outside India within that particular financial year. So just to answer the question, I'm a citizen of India. That's my first characteristic. The second characteristic is, that's the question being put to me, am I an NRI or a resident Indian for the purposes of our case?
Yes.
I am an NRI for the purposes of our case for that financial year. However, I should just indicate to you, as your Lordships already know, my status as NRI is dependent on how many days I'm outside the country or within the country. So that may change from year to year.
Had you been, then there would have been no difficulty. So then,
May not have been. I hope not. I don't know.
because then if you read
At least the top of page 47.
47 clause A,
Right.
there is no requirement with regard to 25,000 and certification of SEMA.
Yes.
And then the only thing is that the grace period would have been available to you only till March end.
Correct. So then, well, first of all, I agree with the observation made by the court. However, I want to just take you back 2 pages to page 44. The question will therefore be that proviso applies only to B. I mean, that's how.
I mean, if you read 40, 45, 46, 47,
That's right.
it will apply only to B.
That's right. Yeah, correct. So, I mean,
It also appears to be their interpretation.
yeah, at the moment, I don't know what will come out over here, but it's possible. So therefore, what am I being punctured or what am I being hit by? As your Lordship correctly puts it, first I'm being hit by the fact that I'm a non-resident Indian. That's the first aspect which I'm being hit by. The consequence of that is twofold. First, there's a cap that your Lordships have seen.
25,000.
Correct. And second, there is all this compliance with requirements to making a declaration in the Red Channel, etc. When I came back to India. So it's something which I should have exported and brought back to India. That's the second requirement of just having even 25,000 I can't exchange. So for an NRI, it is very constricted because it is not just an NRI with a cap of 25. It's NRI. I took the money abroad with me and I brought it back. So in other words, another way of looking at it, it doesn't cover a situation like mine where I'm an NRI who has lawfully left money in India at my residence.
So this notification doesn't apply to you.
The notification does, because otherwise, unless the notification
Because the money is in India, you have not taken it out and brought it back.
all right, then my problem is there's no grace period. That's going to be my argument.
Yes, therefore, this note, if it is construed that this notification applies to only those persons who at that particular period gone out and probably they have taken some Indian currency out and they are bringing it to those persons who had gone out but kept the money in India, which notification applies?
Nothing.
Where is the grace period for them?
So this is absolutely correct.
Yes.
Manoj, I'm just answering this question. So the submission is going to be this. The submission is that Article 14, I mean, let's keep 21 and 300A aside. 14 require, what's happened here? Prime Minister's statement, Reserve Bank of India statement is you will have an exemption or you will have some opportunity at Reserve Bank of India branches even after 30th of December 2016. That was the general understanding, etc. Suddenly we have an ordinance on 30th December which gives a hard stop on 31st of December 2016. Nothing after that unless you qualify for grace period. So one limb of my argument will be that this is arbitrary. I'm just on a 14 issue, we'll see 300A, etc., of suddenly bringing a closure and having no opportunity for someone like me at all. Money kept over here in India. So it falls foul, according to us, of it suffers from a vice in terms of Article 14. That's one. And the second limb of the argument will be, a softer limb will be, that look, you have the power under Section 4. Please cover me with a grace period direction and a notification for someone like me, who's an Indian citizen, who earned this money lawfully, who retained and kept it in India. Surely I just happened to arrive after 31st December. I arrived in February 2017. Surely you should exercise your power. It's coupled with the duty to exercise your power to cover me under the notification. So that's the softer approach in terms of we don't need to strike down anything. But it's something which they have a duty and a responsibility. They have the power for sure under 4. They must exercise that power. So this is broadly, your lordships are correct. This is exactly where I am. Either under Section 4 you cover me, I mean, then I'm happy. If not, if they're still refusing to, because nothing, they've said on affidavit, no, we're not going to do it, come whatever. And we are not obliged to do it, despite all these representations which are made. Then I am seeking the intervention of the court. And if your lordship feels that no, these are matters, etc., which are of high fiscal policy, 1,62,000 of an Indian, what's to the government of India and the larger picture, then I'm going to request your lordship to strike it down. Because then you're taking away my 300A right, valuable property. I'm not a black marketeer. I'm not engaging in some terrorist activity. Nobody claims that I have fake currency notes. So the object which you are seeking to achieve, because you have an object, that's the article, that the classical Article 14 test is there must be a rational nexus to what you're seeking to achieve. How does excluding people in my category, and you can imagine how many there must be of this type. It's very few who've come here before this court and who are petitioning the court. I am, of course, only for myself. Let me make that clear. But how many must be there who came back after 31st of December and found that they had some notes which were lying with them, hadn't carried them out, and they are completely excluded. Anyway, that's something which your lordship will keep in mind. Now, Manoj, may I just quickly return? So then there is at page 53 of that same compilation, the Act, which is in the same terms, but that's really what we need to consider. And after that, Manoj, I might just indicate what we have given. So now, Manoj, I'm just completing this volume 1. But actually, I have to. So just let us take up the list of dates. Most of the statutory documents, etc., are already read and placed before this court. So you may go straight away to the top of page 7, where on 3rd of February 2017, the applicant returned to India. Your lordships have that. I returned to India on 3rd February 2017. I'm on my list of dates. And again, we've given those passport stamps, etc. Then shortly after arriving, Yes, sir.
You kindly also refer to subsection 2 at page 40.
And the three. And the three also.
At 3 also.
Page 40, yes. That's the other power, very much. May I read it?
The Reserve Bank of India.
Oh, yes. Now look at this. This is a very wide independent power. The Reserve Bank may, if satisfied, after making such verifications as it may consider necessary, that the reasons for failure to deposit the notes within the period specified in the notification referred to in section 3 are genuine, credit the value of the notes in his know your customer compliant bank account in such manner as may be specified by it. Absolutely right.
And then subsection 3.
Yes, any person aggrieved, etc., may go to the Reserve Bank. So what happened here, I should just indicate. It will come in my list of dates. I made a representation to the Reserve Bank of India. The Reserve Bank of India rejected the representation. Then after representations were made, etc., they said also that the matter is sub judice, etc. So now for whatever reason.
Is it for the reason that it is contrary to the proviso at page?
Yes, that's how I read it.
Page
They said that
44.
we are not qualified.
No, what is the reason given by them for rejecting your request?
And also, no, because he came.
It's an oral rejection. It will come in my list of dates.
No, because in an individual case like yours, if the Reserve Bank, though your case is genuine, does not consider a case,
Yeah.
and the board also refuses representation,
Yeah.
individual directions could be issued under Article 226 or even under 32 by the
Of course, it must be.
without going to the other question.
Yes, I believe so. I do. That's exactly my point. My point is that under section, that's that power coupled with duty. You have a duty to exercise this.
Then the notification would not apply to you.
Right.
And if the power exercised by the RBI
Yeah.
under 2
Yeah.
or by the board
Yeah.
under 3
Right.
is not exercised in a reasonable manner, not taking into consideration relevant factors.
Right.
In individual cases, we can hold that the RBI is bound
Of course,
to
yeah.
exercise this power.
Absolutely, and I'm going to therefore show your lordship how can there be this kind of resistance and saying that you're either under the covered by the circular or not. That when your lordships will hear them, you will see as to why. There's a reason for that. Why they're taking such a hard.
Because notification is distributed only under 4.1.
That's how I would read it. But I will. So I'm just formulating it from my perspective. I'm in 100% agreement with the formulation from the court or the tentative observation from the court in terms of section 4.
Always subject to hearing them.
Of course, subject to hearing it. So my submission, since your lordship has already captured the point, my submission is both power coupled with duty is both under 4.1 and under 4.2. I must get relief. I mean, that's if we are able to persuade it. And that's it there. So I agree with what the observation made. Because here, I'll just mention it. Of course, while it's an individual case, what Justice Nagratna mentioned just a short while ago was that, can you imagine how many such people there are? There are people who go out of the country, they've left their, example which was given is, There's a grandchild which is born overseas, somewhere, because you have these technical techies, I think, I hope I'm permitted to use that expression. I don't know whether it's parliamentary, but anyway, persons of great technical skill who go abroad. A child is born, the grandparents, because of care, etc., affection, seeing the child, they go there. They've left all their money over here. And they come back after 31st of December.
To tend to the.
Now, what is the recourse as far as they are concerned?
They could be covered under 4.2,
I believe so. I believe they could be covered under 4.2,
but a notification must be issued.
No, it's an individual case.
specified in the notification.
Genuine-
It could be overridden. I'll just read it 4.2. The Reserve Bank, if satisfied after making such verifications as it considers necessary, that the reasons for failure to deposit the amounts within the specified period in the notification referred to in 3 are genuine, credit the bank.
No, that is only a notification under 4.1, small Roman ones. There could be other class of persons as per 4.1.
Yes, you're right.
Roman 2.
Correct. That is also so. That is correct also. So actually there should be a notification by the central government to cover such situations. Anyway, so I'll just flag for a moment. You will find situations. There could be a myriad situations like this. I don't want to be, and apart from people traveling abroad, which is of course my case, there may be people who are hospitalized, etc. There may be people who are temporarily, for whatever reason, infirm, cannot make it. There has to be some facility according to us. So just to complete now this volume, I'm not going to, of course, take you to the.
Prima facie, it appears that subsection 2 and subsection 3 are there to take care of such eventuality.
It could
Because
be.
it doesn't, subsection 2 doesn't restrict to the persons who are abroad.
Right, I agree.
So if a person who is bedridden for 3 months or 4 months,
But in a case country, I agree with your
would also,
observation. Yeah.
in my prima facie would also be entitled to relief under subsection 2.
And of course, for a country as vast as ours.
If somebody is in commanded situation for, say,
Yes,
for 4 months, 5 months,
absolutely right. Well, absolutely right. You could have a situation like that where family members don't know. One of the situations in this court is of a lady who lost her spouse. Now she lost her spouse, so her money she knew. But by the time she located, the spouses where the spouse had kept the money, it was too late. And she's also been excluded from this. So your Lordship may reflect on this on individual cases, but another way of looking at it is, given the vastness of our country and the circumstances, you may have to have a more broader approach on the part of RBI, not on the part of the court. On the part of RBI, you have to have a general circular for circumstances like this. You can't have a hard stop over here, 30th December, we have an ordinance, 31st December, goodbye to everybody. So anyway, that's the background. Now, just to complete this compilation, you may just note, you needn't turn to the pages. Page 62 is my writ petition in this court. The prayer at that point of time was to strike down these onerous conditions in the RBI circular, which is at page 71. Then, of course, 71. Then, of course, your Lordship knows that mine was disposed of. I was allowed to make an intervention. Intervention application, which basically is only to set out facts, is also mentioned over here. Now, just have a look, your Lordship. We just go same compilation, page 84. So, my Lords, I'm sorry. May I just complete that? 1 or 2 dates are left in the list of dates. Page 7, please. Applicant returned to India on 3rd February 2017. Page 7 of my list of dates. Applicant returned to India. 8th February 17, the applicant approached Reserve Bank of India, New Delhi office with the demonetized banknotes, a total of 1,62,000 along with the required documents. RBI refused to accept the old notes. The applicant addressed a letter to RBI requesting it to accept the old notes of amount of 1,62,000 in his possession, which were held in savings for the purpose of the knee operation. Notably, the letter bears an acknowledgement by the RBI. RBI orally, that's the officer, informed the applicant that only those persons who are out of India from 10th of December to 30th December 16 and have declared their currency to the customs authorities at the airport can deposit the same with the RBI. In the applicant's case, he was not carrying the old notes upon arrival, as the notes were lying in his house in his absence. The applicant's case was thus not covered by the circular. Then the 27th February is the act which comes into force, replacing the ordinance. Please go overleaf, page 8. 3rd March 2017, agreed by the refusal of RBI to accept the specified notes, the applicant filed writ petition. Then on 6th March 2017 is the order of this court, which I have already placed before this court. 21st March 2017, the court issued notice on the applicant's writ petition. We have set out the prayer. Then on 7th April 2017, the central government filed a short affidavit in one of the tag matters stating that there is no legal duty on the part of government to extend the grace period and declined to exercise the power conferred under section 412 of the ordinance. On 30th August 2017, Press Information Bureau published a note. This, your lordship will find, is at page 64 and 65 of the compilation. From the reports, data published by RBI, currency in rupees 1,000 and 5,000 denomination in circulation was at rupees 15.44 lakh crore. Now see the next part. Taking into consideration the value of SBNs now reported to have been counted, approximately 98.96% of the SBNs in value terms have come back to RBI after demonetization. In other words, only an estimated 16,000 crores worth of SBNs have not come back to the RBI so far. Now see the importance of this point. By 30th August 2017, they had already received back 98.96% of the notes. So why have this hostile discrimination against people like me, who genuinely had gone abroad, genuine money, and you are just in this area of 0.04%, 0.04% genuine people, and you are saying, no, we won't accept your notes. Sorry, it should be 1.04, 1.98 it is, 1.04. Then 3rd November 2017, this order also I have already mentioned to the court. Top of page 10, we've given you that news report also. During the hearing, the learned Attorney General only submitted that no action will be taken against the petitioners who are before the court for the amount of specified notes held by them and disclosed in their respective petitions. The Attorney General's submission is noted in the news report at pages 84 to 87 of the compilation. Writ petition was declared to be infructuous. That is the cooperative banks, etc. And we've got a news report with regard to that. Then we filed an IA, and then it comes to be tagged, etc. Notice for interventions, etc. Now, just returning back to compilation. So, Manoj, now I'm done with the list of dates. Sorry.
In a genuine case, but if a case is not genuine, what happens? For example, incidentally, you may have gone abroad and you came, and some people will take advantage of this situation, may park their black money with you, and
But
There's a limit on-
I'm not in a case
There's a
which
limit.
that's a concern your lordship will be alive to. But that doesn't mean, I just answer in a moment.
Section 2, the Reserve Bank may, if satisfied, maybe they must hold an inquiry perhaps. Subsection 2 of section.
The lordships have also, now we have the advantage of a 9-judge bench and a 5-judge bench, a constitution bench judgment in Puttaswamy, which says there is a presumption of integrity on the part of the average citizen. Everybody is not some money launderer. That's the logic which this court has used. You can't think and label everyone as a money launderer, and therefore we are going to completely disable all your bank accounts unless you get it linked to Aadhaar or whatever. It's struck down by this court. So there's a presumption that people are genuine, are honest. In my case, there's no doubt in my mind that I am genuine and honest. I've given you the circumstances. Nobody says otherwise. So where is the question of my property being deprived of my hard-earned money and my property?
But under the proviso, I think there is a cap. 58.96 amount has returned.
Has come back.
So there can be no real, apprehension about a lot of money being passed.
Absolutely.
It's only 1.04%.
The foundation. To that question. So I am first of all in agreement with that. Yeah.
Attorney,
Logically.
what do you think? Because, prima facie, we find that subsection 2 of subsection 4.1, subsection 2 is independent of 4.1. And the notification which is issued is under only one, subsection 1 of section 4.
Both.
The duty cast upon the RBI to consider independent, to consider genuine cases independent.
That's right.
And that is independent of 4.1 and independent of the notification.
Let me put it even outside all these
So
provisions.
therefore, some such genuine cases are concerned.
That's right. I close my eyes to all these provisions and say there's an element of fairness. There is something which is missing in the whole scheme of the Act. For the RBI, that's why subsection 2 talks about the RBI to consider. So I'm trying to look into it and I'll come back and say whatever needs to be said. I'm trying to collect the entire
If
picture.
such genuine grievances are resolved by taking recourse to subsection 2 and subsection 3, there might be a hard case where a person must be in a comatic situation
That
for
whatever
6 months.
you're also saying something. Whatever examination the RBI will undertake in a given case will certainly should be on a fair basis.
Yes, on a factual basis.
Correct. And also take into consideration whether it will have the tainted aspect of it.
No, they
No,
can
how
do
do
they
they
consider
consider
that?
language itself
source
says,
the funds.
making such verification as it may consider.
That takes into it. That's right.
It's broad enough.
That's right.
Cover it.
Anyway, on some individual case, I'm trying to look
And
into
Mr.
it.
Attorney, 98% you have already come back, some small thing.
Small
I
people
have
are-
collected some information.
Oh,
I'm
you-
trying
you-
to find out how to
No,
put it in a proper framework, and I'm sure that will be.
So attorney, suppose if some person
Your Lordship, please.
is in a comatic situation for 6 months, and this period comes during that period, his children don't know where his money is. He might have kept in a locker or and if you get
Any number of circumstances.
if you
I
get
know.
satisfied that it was beyond his control to apply within particular period, so in such cases you must provide for some remedy. And prima facie subsection 2 and subsection 3 takes care of that situation.
That's true.
It,
That's the intent.
yeah,
That's
it,
the
it,
intent.
it bestows a discretion upon the RBI and also a duty that to find out whether the results given are genuine or not.
Yes.
That's why I said I'm trying to examine some of the
Yes, yes.
cases. I'll try.
So then, at least Mr. Shyam Diwan's
In fact,
client
I thought
and the learned friend, he's fighting for 30,000 from last so many days. So their grievance would be taken care of.
Attorney, actually, that 30,000, we thought we'll ourselves take care. Then we thought Shyam Diwan will ask for his share. It was beyond our salary.
it's not 1,62,000.
Oh,
So maybe, so therefore, if we can just think loudly about this, at least these independent cases could be taken care of.
Yes.
Let me come back.
You could always verify about the source of funds.
Yeah, as I said, I collected some information, but I want to look at it a little more closely so that if there are some doubtful cases, can we weed them out and see how it comes.
So if he is not in a position to satisfy that his claim is genuine,
Yes.
it can be outrightly rejected. If it can be found out from the account that it was withdrawn immediately before he left India.
What I was trying to look at some of the instances, the bona fides of people who have tendered, the way they have tendered, things like that, all that will be taken into account. Therefore, I think I need a little closer attention to it. I have to come back.
Thank you.
No, well, sorry.
We are saying something in your favor, Mr.
My lord, it is only 2 pages and
Let Mr. Diwan complete. We will hear you.
2, my lord. 77219 of 2017, my lord.
We'll hear you fully.
He has not yet completed.
Yes.
In a lighter vein, I think you have been like Lord Ganesha. So every morning we come, first see you and then go to the, and going out we see you and then go out.
He blesses the court.
And he's also sitting in the middle.
But in every temple, first you will have to go to the Ganesha and then go to the others.
No, my lords, think it's necessary for me to place it because it's on the earlier demonetization case. So it will provide guidance. It's at 101 of that compilation, volume 1. So please just go to, for 1996, volume 9 SEC, page 650. Now I'll just state the points. There are 2 or 3 learnings, at least for us, from this particular petition, this judgment. The first is, according to me, this puts beyond the pale, because it's our constitution bench, so it's authoritative pronouncement, that when you demonetize and rob currency notes of its value, it is an impact on property rights. I mean, it may seem obvious, but now we have a constitution bench which says so. So at least that first hurdle as to whether currency notes were property rights or not is fully and affirmatively answered under 300A, because there was a contest at that time. That's one. Secondly, the manner in which the court proceeded was that it decided on the general principles first, and then it went individual cases with regard to certain cooperative foundations, etc., which came up. That was the broad scheme in which they proceeded and followed. So if your lordship has page 101, I'll just take you straight away to page 104. So this is a constitution bench judgment. I'll read the first paragraph initially. The constitutional validity of the high denomination banknotes Demonetization Act 1978 and the legality of certain orders passed thereunder are under challenge. Petitions under 32 of the Constitution. The Act replaced an ordinance bearing a similar title, which was promulgated by the President and has come into force on 16 January 78. To appreciate the contentions raised on behalf of the petitioners, it will be necessary at this stage to refer not only to the provisions of the Demonetization Act, but also the RBI Act, which empowers the RBI to issue banknotes and imposes an obligation upon it to exchange those notes. Then there's a reference to section 22, section 24, 26. Then please see paragraph 5 on page 105 of the compilation. Coming now to the Demonetization Act, we find that the high denomination banknote has been defined in section 2D to mean a banknote of the denomination of 1,000 rupees, 5,000 rupees, or 10,000 rupees issued by the Reserve Bank. Section 3 declares that on expiry of 16/178, all the high denomination banknotes shall, notwithstanding anything contained in section 26 of the RBI Act 1934, cease to be legal tender in payment or on account at any place. Section 4, which prohibits transfer and receipt of high denomination banknotes, reads as follows. And then section 4 is set out. Please go to the discussion at paragraph 6, page 107. In assailing the Demonetization Act, it was contended on behalf of the petitioners that it violated the fundamental rights guaranteed under 19(1)(f) and 31 of the Constitution since repeal, which were available to them at the material time. In elaborating upon this contention, it was submitted that section 26 of the RBI Act casts an obligation on the bank to make payment of high denomination banknotes wherever tendered, and the central government guaranteed such payment. But on promulgation of the impugned act, those notes cease to be legal tender, notwithstanding the above provision of the RBI Act in view of section 3 thereof, and resultantly, the bank, and for that matter, the central government, stood discharged of their obligations. In other words, according to the petitioners, the impugned act extinguished the debts due owing from the bank to the holders of high denomination banknotes. The petitioners contended that such extinguishment of debts amounted to a compulsory acquisition of property within the meaning of Article 31(2) of the Constitution, and since the acquisition was not made for a public purpose, nor adequate and appropriate provisions were incorporated in the impugned act for payment of compensation in respect of the impugned act, was violative of the above article. Besides, the petitioners contend that they had a right to acquire and hold the high denomination banknotes and to carry on any trade or business by using the same in the course and thereof, and Demonetization Act, insofar as it provided for non-payment of exchange value of high denomination banknotes, except in the cases under section 7 and 8 thereof, it imposes an unreasonable restriction on the fundamental right under 19(1)(f) and (g) of the Constitution. Since it cannot be disputed that the direct effect of the 1978 ordinance is wiping out of a public debt owing to the holder of high denomination banknotes from the state, the other contention of the petitioners that their property was compulsorily acquired has got to be accepted in view of the Constitution bench judgment in Madan Mohan Pathak, wherein it has been held that property within the meaning of Article 19(1)(f) and Clause 2 of Article 31 comprises every form of property, tangible or intangible, including debts and choses in action, and the extinguishment of a public debt due and owing to the state amounts to compulsory acquisition of such debt. The next question necessarily falls for consideration is whether there is a public purpose, etc. And then they get into the point, then they finally find that there is a public purpose, and then your lordship will just note from para 11 onwards, or after para 11, the writ petitions are, there are two writ petitions which are individually taken up and considered by the court. I'm just explaining the scheme. The individual facts, etc. are not relevant. So this is really for the purpose of completeness to inform your lordships that there is a constitution bench judgment. Sorry.
You found it.
You may just see paragraph 11 at page 109, and then I'm done with this volume. Part of this Constitution bench judgment. Now that we have found that the Demonetization Act to be a valid piece of legislation, we may proceed to consider whether the orders passed by the respondent in exercise of powers thereunder refusing to exchange the high denomination banknotes of the respective petitioners of the writ petitions was justified.
So this paragraph 11 is binding on us.
It is. So the Demonetization Act, that act was found to be valid, no problem. And thereafter they went into individual grievances. That's the broad scheme over there. It's your lordship will consider, will apply this case also in terms. I don't think anybody is saying that there's no public purpose as in the sense that that's not my case.
This is binding
But-
on us.
Yes. Now please have a look at the second volume, volume 2, which was titled that compilation, yes, documents on behalf of the applicant. There's just 2 or 3 things I want to point here and then I'm done. Now, I'll just state the point. One of the points which was mentioned yesterday by Mr. Chidambaram was that there is perhaps a necessity for your lordships to lay down under 26(2) and other parts of the RBI Act certain guardrails. And the guardrails are necessary to know as to what are the elements or what is the extent of discretion available, how is that particular power to be exercised, etc. Now, in that context, I just want your lordships to recognize 2 or 3 pages over here. So please go to page 32. Page 32 at 56. I'm just going to read one statistic here. The page numbers are at the foot, I think. So this is using fast frequency household survey data to estimate the impact of demonetization on employment. And please just go to the conclusion at page 56, which is print page 183 of the article. The employment and unemployment estimates created from earlier indicate that the labor participation rate fell by about 3% after demonetization. Employment during the busy October to December 2016 quarter was 0.5 million lower than the preceding quarter of July to September 2016. And the expected spike in employment during the quarter was missing. Employment during the 2 months following demonetization was about 12 million lower. So this is 1.2 crores lower than it was during the 2 months preceding demonetization. And after a 4-month period, when the entire sample is surveyed, the impact of demonetization reduces to a loss of about 3 million jobs, which is 30 lakh jobs. So you see, decisions, of course, there is government policy, etc. They are fully entitled to make policy decisions. Many policy decisions are good, beneficial. Many sometimes it's an element of experimentation. It may work partially, it may not. I'm not faulting anybody on that. The point which was made yesterday and which I'll emphasize in my turn when I come to 26.2 is it's very important for this court to lay down the parameters and the guardrails. That is necessary because look at the impact, Manoj. We're talking about 1.2 crore jobs which are lost in the near term. It was transient. The impact was transient. And then it went down to 30 lakhs after job loss. But 30 lakh job loss, we're talking about life and livelihood. If there are sufficient parameters, of course, then it may not be necessary. But if you feel that there's a necessity to lay down appropriate parameters for the exercise under 26.2, then please consider it because the impact is extraordinary. And the impact runs, it really impacts families, etc. in a very, very, in a manner which is palpable. Now, please go straight away to page, so your Lordship may just see the very next page, page 57 and 58. Same, in the same vein, this is a news report of January 17, 2017. So the first statistic is on employment. The other is this report and study carried out by the All India Manufacturers Association. And please see the third paragraph. AIMO said that that those in the age group 40 to 45 are the worst hit and 40% job losses due to the note ban based on data till December 31st. It also records that 32% of the people in the age group 22 to 30 have lost their jobs. The report says that till December 31st, some 60% job loss were reported in the sector, along with 47% dip in revenue on part of the small-scale traders, shops and micro industries, medium-scale industries, etc. So this is not a critique of the policy at all, not at all. This is only to come back to the court and indicate that the exercise of such powers, if left untrammeled and without any guidance from the court, can have huge human impacts which affect life and livelihood. So I am done with this. The only other page here which I want to point out, you have already seen. Sorry.
Ramdevan, what guidelines you have suggested?
Yes, so I am going to
Have
suggest.
you suggested any guidelines?
Yes, so
Put it in a sheet of paper and.
Yes, so I'll just
guidelines?
answer it in one line first, in addition to what Mr. Chidambaram has covered the ground. My respectful submission is going to be when you see the reports and hear them, at a minimum, when you're taking away 86.4% of the currency in terms of value, at a minimum, and this is based on your Lordship's jurisprudence, there has to be a study. There can't be some general study on black money, trafficking, counterfeiting, fake notes, that there are dozens of studies. They have given some 7 volumes of study after study. There's not one study on the benefit or not the benefit of demonetization as a solution to all these problems. Some study when you are going for 86.4%. I mean, how does anyone apply his or her mind? So I am not on the point.
Made in public domain.
There are 2 elements here. On disclosure, that's an important principle which Mr. Chidambaram has projected. Disclosure of the minutes, the notice, the advice, the agenda notes, etc. That's one element. And then whatever inference, they seem a little coy at this point at least from revealing it to the court, but I'm not on that. It's not even their case that there was some type of meaningful study on what the impacts will be and what the benefits could be in terms of these particular benefits. So some general study that, there's a lot of problems because of black money and there's a huge problem of terrorism and trafficking and etc. is neither here nor there. There has to be, that's our understanding. In the context, because the question is, are there any guidelines which we are suggesting on 26.2? My specific answer is There has to be some, it may be confidential, it may be meaningful, it may be 6 months earlier. I'm not saying it has to be contemporary. There's an element obviously of secrecy, etc., which has to come for a policy decision of this sort. But surely there ought to be, I can't say has to be, ought to be a study is the short answer which I'm giving your lordships in terms of the guidelines. I'll deal with that very briefly. Now only 2 pages are left.
One thing,
Yeah.
if a specific study with regard to demonetization was undertaken, say 6 months earlier or 1 year earlier, and it would have come in public domain, then what would have been the result?
No, I think, let me put it this way. There has to, I think the question is a very important one. Question is, how is the language uses recommendation, your lordship requires that, 2060. Now, when we are talking about, according to us, it has to be an informed recommendation. I mean, that's the basis. I mean, we are talking about Central Board of the Reserve Bank of India. And I mean, if these people don't apply their mind, it will be at considerable peril to all of us. So there is a presumption that this is the highest degree of scrutiny and application of mind, which is going on. Application of mind to what? That's the question which your lordship is correctly putting to me. There may, and I concede and I accept, that there could be possibilities that if some long wide study with some great this thing takes place, there may be some element of secrecy which is lost. That's a valid consideration which we'll have to keep in mind. But was there any study which had recommended demonetization on this scale, which would address those particular objects which they seek to achieve? At least that is the minimum. And was that placed before the board which took a decision? So study one, but I appreciate the perils of what the court has pointed out. That look, where there's an element of secrecy, what sort of study? I mean, are we going to go to every? No, I'm not suggesting that at all. So was there anything at all? I think some minimal study on impacts would be there. Because I don't think the central government the central government at the highest may have some.
We'll have to only take into consideration as to whether both the RBI as well as the government.
Yeah.
While the RBI while recommending and the government while taking a decision.
That's some material.
Have taken into consideration relevant factors and relevant material or not.
Yes.
Or as to whether they have taken into consideration the irrelevant factors and irrelevant.
No, Manoj, I think your lordship has put it very succinctly. I agree with that. The question is whether relevant material, when these impacts are there, now your lordship knows the impacts over here.
In this context,
Yeah.
did the RBI inform the central government that 86.64% of the currency would be withdrawn from the people of India? Was this fact informed to the central government or not?
No, they are quite
Because
coy.
this is the enormity of the entire exercise.
No, they are quite coy
No,
and
no.
maybe with justification.
You have now argued it is for them to satisfy.
Yeah, correct. I am sure they may. But now I've got only 2 pages left. So that one page, which is page 64. So, Manoj, to answer the question, which Justice Nagaratna put.
No, if this was informed, then the question is whether central government would have done this or not.
Yeah, so your lordship is right to put it to them. I have not found anything on the record, but I'll. Now, whether even it was available before the board is not known. This report which I read to your lordship is a subsequent currency report. So this page 64 of this compilation, volume 2, and now I'm done with this compilation, has that figure. It's the Press Information Bureau release where we get that.
Rate close by Mr. Chidambaram.
98.96%, correct? And the last thing which you in that compilation, page 66, just see what they did. Because ultimately when we argue section 4, it's going to be something like this. Government allows cooperative banks to deposit old notes with the Reserve Bank of India. The relaxation comes in the backdrop of reports that many district cooperative banks did not have enough cash to disburse to farmers, etc. And therefore, they took appropriate and suitable action in terms of these under 412. So, I mean, they exercised the power. It's not that they did it. So, Manoj, now I'm done with this. So now may I just come to my submissions? So the first submission I want to make is on Article 300, capital A. Let me just state the points and then I'll take you to one decision of KT Plantation. So number one, there can be no deprivation of property except saved by authority of law. Number two, this has, sorry.
Justice Mukherjee's judgment in that constitution bench, all these points are covered there.
Correct, I agree.
I think we need not go into other judgments.
All right,
It's
you
a
need
constitution judge.
Yes. So there are three things which I just want to mention. Well, first of all, it is quite, I think by now, it's an old judgment I'm citing. So we need not possibly have to actually read the paragraphs, but I'll still mention the paragraphs to you. And I'll mention the points to you on 300A. So, Manoj, at least I didn't find that your lordship sitting as a panel in a constitution bench have so far held that property is a human right. So we have at least 4 decisions of this court in smaller combinations which recognize that
What has been held in the earlier case with regard to 31, Article 31,
yeah,
with regard to property, would
Right.
be equally applicable to 300A.
Yes.
I agree with you. I agree with you.
We'll have to hold that is also a property.
Yes.
No,
And,
none of us have a dispute
Yes.
Right.
that it's a property right in the 300A.
Right.
We unnecessarily, labor on a point where
Okay, so no laboring on the point. So let's just summarize it then.
Unless we disagree with that,
Right.
we are bound by the 5 judges bench.
Correct. So I'll do only 2 things. So first, your lordships have seen my dilemma, which is that my property has been extinguished. You have already fought. That's my whole complaint. That's why I'm here before the court. Rendered not.
Or all of us, we prima facie find that such hard cases have to be dealt with in
I'm-
appropriate manner.
I'm grateful. So that is point number 1. It can't be extinguished or rendered not. And the second is that the law itself must pass constitutional muster. So it's not enough authority of law has to be. So that's well said. So may I just give you paragraphs? Would you like paragraphs? Should I put it in a note? Then you need not note it. So KT Plantation is the constitution bench.
Don't make it too lengthy.
No, I won't. I'll just give you the paras. I won't quote the paras. So that now my 300A point is over. So that's over. 300A. So now we come to the second point. The second point is on Article 14. Now, Article 14, there are many dimensions. So I will.
argument is based upon the proviso to the notification. Proviso to the notification is issued under 4.1I. Now, if your case is covered by 4.2 and 4.3, notification does not apply. Therefore, Article 14 is not necessary.
No, 14 is necessary for another reason. I'll just tell you. So 14 arises in several, there's many dimensions to 14. And it of course, it attacks the very point which your lordship has correctly put to me. And I have noted your prima facie view under 4.2, etc. So that I recognize. But there are a few other dimensions also, which I'll just project and then your lordship will consider. So the first point is, I'm going on the classical equality test. And the classical equality test, as we understand it, is that if you are using classification, then everyone who's similarly placed ought to be in that class. So if there's a single homogeneous class, you can't split that class in an artificial manner so as to result in discriminatory treatment.
Many classification.
Yes, you can't, exactly. Sometimes your lordships have called it mini classification. Now, which is the homogeneous class which I am talking about? I am talking about people who are outside of India during this period. I'm talking about citizens who are outside of India during this particular period of whatever, 8th of November till 30th of December. We are all part of one class. Now, how can it be that someone who lands 1 week or 2 weeks earlier and is able to exchange his money, gets his money? I come in the month of February and I have no recourse at all. Please just consider, my lord, it's a classic Article 14 situation over here.
Mr.
There's a complete,
While,
sorry,
while subordinate notification would be in the nature of a subordinate legislation,
notification.
would be in the nature of a subordinate legislation. While that is issued, all sort of eventualities may not have been taken into consideration. You have created two classes. One is
That's what I'm saying.
one is with regard to resident. It
Right.
presume that a resident
Right.
normally goes for some time and comes back to India, and for them there is no limit.
Right.
No outer limit, no requirement of any certification. They could have gone up to 30th of March and without any requirement could have exchanged it. Insofar as NRIs are concerned, the requirement, NRIs normally, as we understand, are those persons who normally reside out of India.
Yes, so 180 days.
And
We'll just check up.
Yes.
180, 180.
normally in common parlance,
182.
they are citizen of India, but for all purposes they are resident abroad. And for them, such a restriction is imposed. So if we read that subsection 2 and
Or two.
subsection 2 and 3 empower RBI to take a call on such a situation, and there is a power coupled with duty to consider
Yes,
such
I'm
cases.
obliged to that. No, that
Then whether Article 14 would be applicable.
no, see, but that way we have been on this side. of the
That
bar.
question may not arise at all.
No, so I am not saying no to that at all. I am, see, the reason I'm projecting, first of all, I'm agreeing with the court. I'm agreeing with the court that if I get relief on,
The classification between an NRI and a resident Indian is a reasonable classification.
it depends for what purpose. See, that purpose is because of the grace period definition here, correct? 31st March or June. That's the scheme over here. So I am not quarreling with that. Let me just restate it. Maybe I didn't make myself.
Yours is one of those very few cases which would fall in the category of hard cases.
No, I'll
Had
tell you.
had you not been out of India for a particular number of days, then you would have been a resident Indian.
So I am looking at it differently. Sorry.
And entitled to treat it in clause A.
No, so I accept that. My point is a little different. Yes, the approach is different. First of all, Malad, I want to accept that if I receive substantial relief, I mean real relief in terms of section, whatever, an appropriate direction because of power coupled with duty, then this issue which I am raising may in a sense not arise in terms of determination by the court. But it's important to recognize the issue because it elevates the degree of the duty, the bounden duty of RBI or the case of or the central government as the case may be. Now, what's that point? The point I am making is there's an artificial line which is being drawn on the 30th/31st of December 2016. There are people who arrived before. Just look at the situation. There are people who came back into the country before on 20th of December 2016. They had booked their, nowadays your lordship knows the only way to get an affordable ticket is to book it well in advance. So some people have plans to book it in advance. Some people have plans to have booked the ticket at the time of their leaving well in advance. It's a reasonably fair ticket. I was to come back in the month of February 2017. Now, the question I asked myself is, the first point I'm raising just on this homogeneous class is that look, how am I any different from a person who came back to India, say on the 20th of December and therefore had time, and me who relied upon or who was aware of the Prime Minister's declaration to the country, the Reserve Bank of India statement to the country, which said that people, don't worry, when you come back, you will have an option of going to the Reserve Bank of India. I am in the same class. Now, this is my point. I want to say nothing further. I am in the same class to artificially exclude me from a class of Indians who didn't arrive, even though held valid currency in India, is according to me an arbitrary classification. So this is my first point.
According to you, there is no nexus with the classification.
Now that's the second point. The second point is that the nexus is, or ought to be, that's what they've said repeatedly, black money. Second is fake notes, that means counterfeit or whatever fake in some other manner.
Drug trafficking.
Drug trafficking. And yes, so these are essentially the trafficking, fake currency, etc. and terrorism. Your Lordship recalls that also, terrorism. Now, what is the connection with my hard-earned money and any of these objects which they are seeking to achieve? So that's the second infirmity under the classical test under Article 14. There's no rational nexus. I'm sorry.
When rules are general rules applicable to lakhs and crores of people are being made, can individual cases be
They must be.
consideration?
No, they must be. In my respectful submission, see, Manoj, this is the other way of looking at it is the rational nexus which you have, terrorism, etc., you have to have a caliber. I'm moving into my next point actually on proportionality. That's also an aspect of Section 4, etc. You have to have a proportionate set of regulations. You can't deprive some people of their money when they have nothing to do with terrorism and they've got nothing at all to do with any of this counterfeiting, etc. And I have these genuine notes and you can see my notes. And it's 1,62,000 of hard-earned money which I had taken out, which I had kept at home. It's not an uncommon circumstance at all, Manoj. And therefore, there's no nexus to the object which you're seeking to achieve. And you cannot you can't have a situation that because this is in some larger public interest, my fundamental right or my constitutional right will suffer. You have to have a calibrated response either through appropriate notifications or through appropriate rules and regulations or through an appropriate scheme by which a person like me cannot be disadvantaged. Anyway, that's my submission. That's my submission with regard to this. Then there's an element of manifest arbitrariness. Now, why am I using this expression manifest arbitrariness? We are emboldened because no less than the Prime Minister of India gave an assurance to the people of India. Now, once the Prime Minister of India says you will have RBI counters to go to, and the Reserve Bank of India and the press releases which are contemporaneous echo the same sentiment, then the question I ask myself, isn't it manifestly arbitrary to introduce an ordinance on the 30th of December which has a guillotine on the 31st of December? 1 day given. How can anyone change his or her affairs? So therefore, the measure and the baseline for what is reasonable ought to be, we have the advantage of a solemn assurance and a statement made by the Prime Minister, no less. In a situation like that, that is surely the yardstick of reasonableness. If that is the yardstick of reasonableness of whatever people expect, etc., you can't suddenly introduce an ordinance on the 30th of December and saying that I'm giving you no effective window to change your money at all. And there's a hard stop which comes in on the 31st of December, and that is that. So this is my other element with regard to manifest arbitrariness, founded on the representations which were made to the country at large. And finally, I've already mentioned the doctrine of proportionality. Mr. Chidambaram has explained that at length in the context.
Relied on my learned brother's judgment.
Yes. So that's a useful. So, Manoj, I will state now. Let me just state there are at least 3 decisions of our court which I'm just indicating, and I'll tell you what they say as well, and then we'll, if necessary, go into the paragraphs. So now, as far as proportionality is concerned, it arose in the Puttaswamy 5-judge bench judgment. I'm not going to the judgment. I'm just explaining it because I'm going to give you a note with the relevant paragraphs. One of the requirements was one of the challenges in Puttaswamy before the 5 learned judges was the mandatory linking of Aadhaar to bank accounts. And this was brought about by an amendment to the rules which deal with money laundering. So the argument on behalf of the state, the union government was that, look, this is money laundering, this is anti-terrorism, this is this, this is that. And therefore, this is a matter of financial policy, etc. Please allow and sustain this linking. What this court said is that you cannot have, that's the expression which your lordships have also used.
Yesterday, Mr. Chidambaram had read those paragraphs.
Yes, those paragraphs. So we have now 2. So he read to a couple of those paragraphs which clearly indicate that just having a ritualistic incantation, that is the paragraph which they read, is not sufficient. And if this is hard-earned money of individuals, so what was the principle? The principle applies over here. You have crores of people with bank accounts across the country. You can't disable valid earned money value in those bank accounts by saying that if this is not linked, then as far as that particular money which is lying there, there'll be a presumption that this is whatever proceeds of crime or money laundering or will fall foul. It will fall foul of the money laundering rules. And this court struck it down and said, using the doctrine of proportionality, that there has to be something which is more calibrated and reasonable. So this is my final dimension. As far as Article 14 and proportionality is concerned, There ought to be something which allows a route out for persons such as me is concerned. Now, I want another, I'll just mention another item and then I'll put it in the note. I think there's a very important aspect of dignity in this case. The very important aspect of dignity. Dignity has now been recognized by the 9-judge bench in Puttaswamy as being basic element as far as constitutional values are concerned and the right to life. Now I'm on 21 and dignity. I would respectfully submit that traveling to the United States to visit a son and a family member, son, daughter, whatever, is part of our overall understanding of dignity, of having family, of emotional bonds, of renewing those bonds, of enjoying the company, of looking after whatever grandchildren if there are, and being looked after. All of this is a very important facet of dignity. And you cannot or you ought not have a situation where I am suddenly the Prime Minister makes an announcement. I have to immediately pack my bags and rush down. Forget that issue which I mentioned about the statement and the assurance made to the people of India. No, dignity is something which I carry along with me. Your Lordship have used that expression also. I mean, in the context of privacy being a portable right. It's a traveling right. The dignity comes with me. You have your Lordships in Maneka Gandhi, etc. Right to travel abroad has been recognized. So the right to travel abroad, the right to travel and reside with my family, the right to stay abroad, all of that cannot be diminished by saying that, all right, go and travel abroad, stay abroad, but your 1,62,000 or whatever amount which is remaining over here vanishes. So this impacts established rights in terms of dignity, the right to travel abroad, and important dimension of property, not 300 days so much. But the security of property is also something which is an element of 21. When I traveled abroad, I knew that this 1,61,200 was secure in my home, whatever, under lock, cupboard, etc. And all of a sudden,
in a lighter vein,
yeah,
if a person goes out of country
yeah,
for a considerable time,
yeah,
rather than withdrawing the amount from the bank, he would deposit the amount in cash to keep it safe.
yeah. So
In a
here,
lighter vein.
right. No, so here you will see my deal. But anyway, I have a withdrawal slip, etc.
You have a withdrawal slip, so
Yeah, right.
rather than
I inquired actually.
having a threat of theft, and if one is traveling for 9 months,
Right.
ordinary course, you will say whatever cash I have, I will put it in the bank so that it is safe.
Or locker.
Or locker.
That may be. So what had happened here, I inquired. Fortunately, he didn't have to go through that knee surgery. He had collected certain money, etc., for a knee surgery, but then the treatment outside the surgical thing worked for him, though he had to undergo certain other surgery. We were not on that. So that was the original rationale for having withdrawn the amount and kept it in safe custody. So this is my point.
But at
Now,
any rate, they are relaxed the whole thing in so far as cooperative banks are concerned.
Yeah, absolutely.
See, that was done in June, 6 months later or
Yes.
6
Yes.
months later, they have relaxed
Correct.
for cooperative banks.
Right.
So that all the money which they had stocked, they could exchange.
Absolutely. Exactly what I wanted to say.
If you put it to the learned attorney, I think he will
Respond to that.
respond to that.
Yes.
All right. Now I have 2 points. Sorry. Yes. So, Namalaj, I have 2 points to make. For one is on that your lordships have already grasped it. I don't know whether you require me to make any further submission. I suppose the answer is obviously no. Any further comments with regard to that section 4? I think power coupled with duty, your lordships are completely alive to that.
Yes.
There are, I mean, it's a well established.
You can give in your written note whatever. If you are relying on something.
Now, then I will, your lordship will just give me a moment. I mean, there's a minute left or less. Now, the final point which I wanted to make. May I just continue? I'll just wrap it up immediately after.
How long will it take? 5 minutes?
Maybe 5 to 10 minutes. I'll just, because there was a moment.
5 minutes.
I think
Complete.
rather than finish it right now.
All right, fair enough. Manoj, yeah. No, they can wait there, Manoj. I'll be less than 5 minutes.
They will be hearing the
disturbed by
arguments.
them.
Oh.
You will disturbed by them.
So now I want to just step back. Sorry. Aspect of section 26(2). That's all. I'll take a minute or two on that. Now, Mr. Chidambaram has made exhaustive submissions on that. So point I made a short while ago on this 86% of the entire currency. First, the expression is recommendation. 26(2). I'm only on 26(2). Now, if it's a recommendation at this level, did they, at least the basic elements, I believe, ought to be told to this court, and one of them has been correctly pointed out, which is the quantum, 86%. Did the central board even know about this? That's one. Second element I suggested in terms of guardrails is some study, contemporary, specific to demonetization. I am not going.
That you already addressed.
I have mentioned it, and some study, some basic study, but not some general study on black money, and those are sort of cheaper by the dozen. Those you will get any number of on some trafficking and this and that. The point I'm making is demonetization as a solution. The impact after 86%, whether that was known, and the impact, I think that's very important. Otherwise, my only additional point is the expression recommendation takes in or draws into it conceptually and information being received by the party recommending, deliberations at the highest level before making the recommendation, and thereafter some kind of a meaningful application of mind. Now, unfortunately, using that expression ritualistic, they have in a ritualistic manner on those affidavits, which Mr. Chidambaram yesterday pointed out, those 3 or 4 paragraphs, said that there was a communication from the government to them, to the central board, meeting was convened, and the whole thing and the recommendation arrived, and pursuant to that, a decision and call was taken. I don't believe the requirements of 26(2) are also fulfilled. I'm very grateful. Thank you.
Thank you very much.
Who will start at 2?
Will consider the applications which are now pending.
No, I think substantially it is argued. Now we will ask the learned attorney to respond.
On the tax models, we are almost similar here also.
All right, you have said now that we have now the attorney has said he will examine. Please listen to us. See, if the attorney said he will examine, that aspect, whether how to safeguard your interest, he will come back.
The only difference is, my application is
That should be a part of your representation if the attorney agrees.
we had made representation as per their.
You make one more, we will allow you, nothing to worry, provided we should, all right.
Well, I will seek your lordship's indulgence to start after 2, because the legal issues which Malad supports half of the submissions made by Mr. Chidambaram on 26(2), but there are many things which needs to be brought to
But
your.
how long will you take? 15 minutes we will grant you. 15 minutes.
If I satisfy lordship 15, maybe lordship will grant me more intelligence.
No, 15 minutes, and you can support by your written submission
Lordship.
thereafter.
I'm on
15 minutes, 15 minutes.
Lordship, please.
All right. See, everything is covered now. What is there?
But mine is
Anyway, all your names will come in the judgment. Nothing to worry. SEC it will come.
mine is a slightly different application.
No, all your names will come in SEC. Nothing to worry.
I am seeking specific directions for investigation into the act and conduct of the RBI. Now,
All right,
my
it will take 5 minutes. 5 minutes.
Documents.
Only 5 minutes. 5 minutes. Yes.
I will take 2 minutes.
Huh?
I will take 2 minutes.
That is at the end, no? That's 30,000 rupees issue, no?
Yes, madam.
All right, we have understood that.
Only 2 minutes I will give. 10 minutes.
He repeats any of the submissions, then we'll stop them there.
Yes.
Any repetition, we will stop.
Yes, ma'am. Yes, ma'am.
In fact, my lords, on applications,
5 minutes on a.
there would be only the difference in the hardships that people would project.
All right,
We are not going into the individual hardships.
see, if a provision is made as my brother suggested, and all problems will be solved, including 30,000 issue, right? But you have to spend 60,000 for that.
We will be saved over 30,000.
Then, Mr. Attorney,
Your Lordship.
address at 2:30. Your time, you should start at 2:30.
Very well.
You'll be finishing
Very
this side by
Very
half an hour.
Very well.
Please start at 2:30.
Very
Huh? No 15 minutes, 2 minutes. We have said this judgment is res judicata now. No. We have already said 2 minutes. Right.
There are some tax societies also which has to be taken care of. So, can you give me just These are not factual because their amount.
We are giving you 2 minutes, no, you can state that. No, this is res judicata now. It is binding on us.
I will.
take 10 minutes. I won't argue on the legality. Let me just tell your lordship about the facts of
Yes,
the.
yes, tell us.
In this, it's in IA number 152009.
Just 1 second.
We originally filed a writ petition. Thereafter, we were told to file an IA for intervention.
IA number 1.
152009. This is an IA 26770.
Which year? 2020, which year? Of what year?
So this
Bhushan, what?
152009 is of 2022. This is an IA for direction. And the intervention is IA 26770.
Anyway, that is going to be allowed, nothing.
Pardon not?
That is going to be allowed intervention.
Yes, yes,
We are hearing.
I just wanted to tell you about. Now the facts, my lord, why we couldn't deposit are given at page 18 of this.
You that
IA.
I, yeah? You that I, just 1 second.
Basically what happened was.
Sarala's Rivasto is the
Yes,
name.
yes, yes.
But one thing we wanted to tell you, we are sorry we are making you work on a Friday evening also.
No. I'm very happy to do that, my lord. We are sorry that we are making your lordships. So what happened was, my lord, the money belonged to the petitioner's husband, this lady's husband, who was a lawyer who went into a coma shortly prior to his death. And thereafter he died on 6th April 2016. And his wife was not aware that he had kept some cash, which was discovered by her only on 19th January 2017. And she immediately wrote to the Prime Minister that you have extinguished this window by 31st December, etc. Therefore, please at least make an exception for such kind of cases. So therefore, she has narrated what happened. This is what happened. This is.
So, Bhushan, we have already put it to the learned attorney as to in such sort of hard cases. And this particular instance was also given that the particular person who is in a coma, there should be something. Prima facie, we have observed that in view of.
Now, the thing what has happened is, my lord, of course, I am appearing for this lady. But the fact of the matter is, my lord, there would be many such people who would not have been able to come to this court. And therefore, the appropriate relief and my respectful submission, my lord, in such cases would be to say that this sudden extinguishing of the date or even fixing any arbitrary deadline, because the person, in this case, my lord, she discovered the money in January 2017, which was before 31st March, because the Prime Minister's speech said window will be given till 31st March. But suppose she had discovered it after 31st March. I respectfully submit that not allowing even genuine cases who, for one reason or another, suppose somebody was abroad and he couldn't come for any reason before 31st March, and he could only come thereafter. Therefore, my lord, any arbitrary cutoff date which prevents even genuine people from getting their money, so to say, would, in my respectful submission.
That is already argued by Mr. Diwan.
Yes. Would make
we are made it clear that we request you not to repeat the same argument.
Yes, I am not repeating. I am just saying that, therefore, that however your lordship shapes the order, it should be a general order, because there would be a large.
Yes. We are going to do that. All right, we will hear party in person and then we will come to you, right? Sir, maximum 15 minutes we have told.
I will
You can give a written submission, we will go through.
And I will, Manoj, draw your lordship's attention to
What's your name? Who are you here?
Viplav Sharma, Manoj. My petition number is Manoj 943 of 2016.
You are a petitioner.
Lordship.
That
Item 17 Manoj. And there is also one IA which I filed later on for placing additional grounds on record.
You are Mr. Viplav Sharma.
Lordship praises.
All right. Tell us,
Manoj, there are 2-3 things.
how much money of yours has gone?
No, Manoj, I have, Manoj, been privileged to appear before Lordships in Bihar dissolution matter, and my lords, I assailed the governor's accountability to the report, my lords. It's only purely constitutional matter.
All right, tell us, come to the point, come to the point. Right.
My lords, the first of all, my humble submission is that section 26(2), where under all this thing has happened, my lords, it is, my lords, to serve the purpose of the RBI Act. This is my first respectful submission. And it is, this RBI Act, my lords, is made by the Parliament in terms of entry 38 of the Constitution of India, my lords. So therefore, that sphere and the field of RBI cannot be enlarged. It has to be in terms of, my lords, the purpose it is meant for. Section 26(2). That's my first aspect. And my lords, 26(2) has a very simple language to understand. And lordship, I'm not saying, I'm not going into that, what interpretation on that. So it has to be interpreted in the manner it has been written. And it does not provide for the whole of the currency to be demonetized, which has been argued by my senior colleagues earlier. So I will not go into it. Now, respectful submission is, there is a concern of the Honorable Court that what would happen that if there are yardsticks and safeguard measures to check on the implementation of 26(2). So your lordship see from 22 to 26, 25, 24, 33 and 42. 42 is more important, is that the minute one currency is declared to be no longer a legal tender, in terms of section 26(2), which according to the law with limited knowledge analysis, it has to be series and it has to be specified. So therefore, the minute it happens, instantly section 42 triggers, my lords, because it provides
It is 42.
lordship.
Very good. RB.
My lords.
Just once. Book. All right. 42, cash reserves.
Lordship reserves.
All right, 42.
Cash reserves of scheduled bank to be kept with the bank. So every bank included in this second schedule shall maintain with the bank an average daily balance, the amount of which shall not be less than such percent of the total of the, lordship is important, of the demand and time liabilities in India. So each of the branch has to have minimum necessary cash reserves for a particular branch, and because they size it up, because the particular branch needs to be insured also. So only depending on the size of the branch and depending on the size of the accounts it maintains.
All right, what is that you want to say out of
My respectful summation is the minute that
now that you are an advocate, so we can ask you freely.
Lordship,
I thought you are a
Lordship,
party person.
No, my lords.
You are a party in person, of course,
Lordship,
since you are a practicing.
Privilege to assist your lordship. The point I'm trying to make it is, my lords, let's not for a minute, my lords, take this notification as a simplicity notification. Let's see how it has been affected the mass. By one, this notification, 86% of the currency has been killed overnight. It has been declared to be no longer tender. So the currency means the currency which were there in the
Wherever it was.
Wherever it was, Yorkshire, I'm obliged. Wherever it was, even in the bank. So therefore, my lords, and in terms of my lords, section 22(2) and subsequently 24, the issued department of the RBI will only issue the currency only in exchange of what it is getting. So what happened on 8th of November, the overnight, this currency was declared to be no longer a legal tender. So therefore, according to my opinion, which I'm assisting your lordship, is that how the legal tender will go to the issue department for it to release the currency in lieu thereof. Because overnight, the particular currency against which you have to print more currency and issue more currency was no longer there with issue division. So it could not have been done. So the point I'm trying to make home is that it is for this reason, 26(2) is only for a limited purpose for any series what Mr. Chidambaram has argued in length. And in my writ petition, if I, Lordship, may, I will just take your Lordships to the.
Sharma, please, if there is any new point, then please address on it.
Yes, Maharaj, this is the first point I'm saying, Maharaj.
That is already canvassed by Mr.
No, on 26 it is there. Secondly, Maharaj, this 26(2) has been issued by the central government, if your Lordship had gone through it. It is running foul to Article 77(1) of the Constitution, because all the acts of the central government has to be done in the name of the President of India. And this notification is, Maharaj, not in the name of the President of India, so therefore it runs foul to the Constitution. So therefore, only on that score it is unconstitutional. Can you have, Maharaj, for a minute, the notification, it has not been issued in the name of the President of India. And Article 77(1) says, Maharaj,
Authenticated. It is authenticated.
it says conduct of business of the government of India. All
That's all right.
Lordship.
You need not.
Ma'am, just Maharaj, thank you.
You have understood.
Maharaj, this is fine.
Yes, attorney, you must explain this point. Just now you heard what he said.
I'm sorry, I'm sorry.
Constitution.
Distraction, sir.
And third thing, Maharaj.
No, he says it was not issued by the President of India,
It was not.
notification.
And that is what I asserted in my writ petition, Maharaj. I said
Ah.
so.
You may have to answer this question.
I'll answer.
Yes, what is the third point?
Third point is very, very simple, Maharaj.
Ah.
In the notification, the premise which has been given are three premises, which they said, to curb the black money and all these things. Your Lordship.
Yes, we know.
Maharaj. Now, against that, coming back to my first point, that 26 and RBI Act is not meant to serve those three purposes. It is only meant for doing the currency business and the banking business, nothing beyond until 38. So therefore, and as regards to all these three issues, Maharaj, and there are already very strict laws in place, statute. For example, as against black money, we have an Income Tax Act, Special Bearers Bonds Act, Narcotics, Drugs and Psychotic Substance Act, Prevention of Corruption Act, Benami Transaction Act, Foreign Exchange Management Act, the Prevention of Money Laundering Act, the Black Money Act. All these statute provisions, Maharaj, have a safeguard of taking the black money, who's having the black money taken by surprise. The question which I was, Maharaj, hearing from yesterday, the concern was that how it should happen that nobody should come to know about it, demonetization, so it serves its purpose. So the respectful submission is that this particular act, these acts, are meant to serve those purpose which is assigned in these ones. And in as regards to the Maharaj, other laws, Central Board of Taxes, Enforcement Directorate, Financial Intelligence, these are agencies who commit raids and they can recover all the black money. And as regards to Maharaj, the other issue as against the fake currency, Maharaj, the law, the Unlawful Activities Prevention Act is there, Terrorist and Disruptive Activities 1987 is there, Maharashtra Control of Organized Crime Act is there. And as regards to Maharaj, other issues, all this separate act is there. So respectful submission is this. When for these purposes, the field is occupied, we have a very stringent laws and effective agencies who work to unearth all these black money wherever it is parked, or to unearth the crime, possible crime it is there. So therefore, this 26(2) cannot be used for those purposes.
All right, we have understood.
Lordship, please. Only one last point. Only one last point.
Wait. Yes.
Maharaj, only one last point. Just I will leave there on one point. Maharaj, whatever has happened, I am not onto the point, as was being argued by my senior colleagues, that they should be examined, what was the reason, etc. Not required for the one reason, it's a government and it has to run the affairs of the state. So whatever they are contemplating, it is there within their Maharaj's executive authority, they can do it. But the minute that document gets public and it is implemented, then it is subject to judicial review in case if anybody is there. So they can come here. Now, so Maharaj, so therefore, this kind of a notification decision was such that overnight, the whole country, 140 crores, Maharaj, they lost their currency, whatever currency they was defined, which was kept with them in their house, and that violated Maharaj Article 14 and 21, right to life.
That you have already
Yes.
said.
So then, no, what I'm saying, the point I'm trying to make, that it got immediately, Maharaj violated.
By Mr. Diwan, by Mr. Chidambaram.
No, Maharaj, I'm saying, I'm trying to make a slight distinction. I'm only one line. Maharaj, it got affected the very same minute. So therefore, this government, which has been formed to run the country in terms of the constitution, it could not have done that. So therefore, this declaration what they did, Malaj invites your lordship's attention, Malaj, and it has to be seen in the manner that the whole country, Malaj, is not put to same kind of a jeopardy again. That's my respectful.
All right, sir. All
So thank you, Lord.
all right, sir. All right. All
I
right.
have 30 seconds, my lord.
2 minutes.
30 seconds.
We will hear you. Please wait.
30 seconds, my lord. 30 seconds.
We will hear you. Did we deny?
Yes, I am the lead petitioner in the main matter, comment petition number 906 petitioner in person.
You are a party in person here. All right. Very good.
Versus Union of India.
All right. Tell us what is your point. Tell us. You can propose, give your brief written submissions if you want.
It has already been submitted on 4th level.
All right. What is your point? Come to the point.
I will just point out few things
Hmm.
and that's where I will close.
Huh.
But the media and other petitioners have canvassed, oversimplified a very complicated subject here. So to understand the economic impact, decisions, different variables must be considered. So I have brought in before this honorable court, those different variables. Those are the reports from the US State Department, Financial Action Task Force reports to derive the points that I am making. In my written submission, if Master may circulate that.
Hmm.
But with regard to the effect of demonetization, I have canvassed my argument that prior to 2016, when the demonetization was declared, as per the US State Department report that was published in 2016, the terrorist incident, those were ranging in 1927.
What is the point you want to make? Tell us the legal question. See, we know the fact.
These are relevant.
What point you want to make? Tell us.
Post demonetization,
Ah.
the impact was
Hmm.
prior to that, whatever the number of terrorist incidents were there,
Hmm.
while the globe was facing 15% increase as per the US Department of State report,
Hmm.
increase in the terrorist related incidents.
Hmm.
India saw from 2017, 18, 19, an increase of 30%.
Hmm.
So in a way, the demonetization exercise provided that impetus that the India could curb those terrorism related activity.
Hmm.
And in fact, there was a 45% decrease in female.
You should have briefed Attorney General on this point.
No.
You see, let him, you do one thing, you please wait, let the attorney reply. Thereafter, if you want, we'll, because you are supporting that. no?
Yes, ma'am.
Then you wait. Why are you opening the file? Let attorney start.
Yes, the petition.
Let not be considered.
But what is the relief?
Why you, what is your relief?
But I had been seeking those particular relief with regard to the benefit of the society so that those, because.
So what is the relief in the, if you are, you will be, if you are challenging
I
the,
was impelled by, there are certain limitations. The limited.
you want a judicial pronouncement from us. That the denomination have.
Let him wait.
My
All right,
request
wait.
limited for the
Let us hear
benefit of the
attorney.
society.
Let us hear attorney.
If you will give me an opportunity, Milad.
Why don't you wait? We will ask you, we will invite you rather to argue, right?
I'll brief you.
All right. Yes, tell us.
I appear in item number 501.7.
What is your point?
Your Honor, I am in possession of 3.19 crores of demonetized expenses still.
Very good.
And that is because.
It's very huge compared to 30,000.
And 1.6.
But are you threatening that we must pay that money to you? No, no.
No, sir. No, sir. Not at all.
Because you have promised one gentleman. no?
No, sir. The Lordship would appreciate what led to these circumstances. My banker, Axis Bank, denied in writing to me that they cannot accept further cash deposits from me by email dated 21st of December 2016.
See, we are finding a solution to that. Please wait. We are finding a solution to that,
The Lordship would appreciate. I approached RBI.
All right, now we are finding a solution. We will give you a solution. Please wait. All right.
If I may calculate the list of dates.
Huh?
If I may.
Not necessary. We will give you a solution, right? All right. Yes, come.
Representing the primary agriculture credit society.
What do you want to say?
So I had some money which was not allowed to be deposited. So this court, wide order dated 16th.
Please wait. We will find a solution to that. Please wait.
Very small direction. NABARD has already been directed.
Wait, sir. We have asked a question to learned attorney.
My lord.
Please wait. Why are you repeating all this?
Wait, please, my lord.
How much money you have? Huh? Wait. No, doesn't matter. We will find a solution to that, right? All right, sir. All right. Yes, one by one. Yes, before. Yes.
We were allowed to withdraw only 24,000 in FD for quite long time from the DCB. We were not able to disperse the money even for the loans as well as other supporting facilities because we are primary agriculture societies and the law governs us is completely different. And I have annexed the law which is binding us. And they have, Reserve Bank of India has clearly told us that you are not actually coming within the ambit of Banking Regulation Act. Still they have.
Please wait. We will find a solution to that.
My lords,
Yes, one by one. Here, sir. All right. Wait. Should we repeat all these things to you? Yes.
please, my lords. My lords.
Wait. Yes, sir. Yeah, you tell.
I appear for the Global Organization of People of Indian Origin.
Huh.
Because the GOPIO is one of the oldest organizations which has.
Come to the point.
The point is, the date that was given for the overseas citizens of India, which are in two categories. One is citizens, OCI card holders who are citizens of foreigner, and the others are NRIs who continue to hold their passport, Indian passport. But same 31st December was given, that was extended to June 2017. I'll give you statistics about how many workers we have in various parts of the world.
We have already said we will find a solution to that.
The legitimate the earnings of theirs, they should be able to deposit. Millard, one more point.
Please wait.
Just one more point.
These are all pointless points, sir. All right, next, no, sir. We will find a solution to that.
My submissions may warrant a reply from the union. My lords may have the specified Banknotes Act 2017.
No, what is the point you want to
My lords,
make?
as per section 4 of the Act, only two categories of persons can tomorrow convert. I'm talking about tomorrow. If what's falling for my laws is that we will have a mechanism, or we hope to have a mechanism to convert these 1.4% people who are left.
No.
This act.
No. We are only trying to find out a mechanism wherein persons with genuine difficulties could not deposit within a time and whether as per the.
Yes, my lord. I'm coming to exactly that. I'm coming to exactly. My laws may have section 2 or section.
If you are coming exactly to that, what is the grievance?
My lord, the grievance is that the act says that if the RBI is not satisfied, I will have tainted money. Presumed taintedness in this kind of arbitrariness.
Oh, that is subjective. Please wait.
Has to be struck down.
All right, let us see. We have understood. Yes.
My application is slightly different. I'm seeking directions for an investigation by an independent agency of the Act and conduct of the RBI. Now I have documents to substantiate the same. I have filed a compilation and application law which is before your lordship. I would like if your lordship will consider taking up.
We will consider. All right.
There are serious issues, Lord. I'll tell you the three issues which are there.
Tell us.
One being, Lord, the 500 new design notes, Lord. They were printed by the RBI. I've got a document by the RBI, Lord, the printing press, in 2015. Whereas the notification for demonetization came in 2016. They couldn't have done it. Without the recommendation of the board of directors, it couldn't have happened. I have a document wherein the printing press, there's the reply in the RTI wherein they say that the new design notes of the 500 denomination were printed in the year 2015. Second point being, Lord, I have documents to show that prior to 2016, the quantified amount of 500 and 1000 denomination notes which were being circulated was 14 trillion, some odd figure. When they received back after demonetization, within 3 days, they received 15 trillion. So 1 trillion in excess of what they were circulating. Now it is not their stand that this currency was fake. They have deposited this back in the bank accounts. I have got this information from the annual reports of the RBI.
Everybody is saying that 98.6
No, my lord.
You are saying it is more than 100%.
Precisely, my lord. That is why, therefore, I am asking your lordship to look at it. Third point being, my lord, I have the minutes of meeting of 93 of the board of directors, 94, and then 2016, which led to this new design. The new, whenever, my lords, a new denomination has to be incorporated, it has to be incorporated into the new family. It has to be made into the family.
You must separately argue all those cases.
I will-
See, this
my
is not the
predicament
scope
being-
of your case.
I tell your lordship what is my
It's
predicament.
totally beyond the scope of.
Understand that, my lord.
We'll detect it.
देखो उनका detect कर दो. Detect, which is your already. We will hear you separately in that case.
No, just one more request, Lord. I have already filed a substantive petition which is pending before the Bombay High Court, a writ petition. Now that is not being heard. That is the reason I filed an IA here.
That's right. You. What is your writ petition?
Records of that writ petition.
What is your writ petition here?
Here, it's an IA.
IA.
It's an IA. I filed an IA.
Then you withdraw this with liberty to file a fresh petition. This will not come within
Then your
the.
lordship may grant me this liberty that I'll file a
Already
substantive
dismissed
petition.
as
in the
withdrawn
Supreme Court.
with liberty to file a fresh writ petition. You face the music. You also you withdraw with liberty to pursue your writ petition before
That's
Bombay.
not getting listed. That is the.
We
reason
will
why-
say that. All right.
No, I have.
Dismissed as withdrawn. Please listen to us.
Kindly consider one request. I'll leave it at that. Your lordship can call that writ petition here.
You don't need a constitution bench for that. Likho. Application so and so dismissed with liberty to pursue the writ petition said to have been filed by the petitioner pending before the Bombay High Court. All right. Over. Yeah. Next case.
Well, then I withdraw my application with the said liberty.
All right. Dismissed as effective the same. All right. Likho. Dismissed application dismissed as with liberty. Over.
64,
Ah.
Lord, it's 21 lakh rupees were lying in the court. my
That
lord.
we will provide, sir. Wait.
Court, justice delayed and currency denied.
Very nice.
No use, sir.
Yeah.
I moved the application allowed to release so that I can convert.
Just wait. Wait.
Sign-off have given assurance for us currency of about 49 lakhs, not having contact with the agriculturist, could not deposit. That's the only one.
Wait.
Agriculture is 49 lakhs.
See,
49 lakhs, three agriculturists, different applications, my lords. The total I am saying, so that to curtail the time. Three different agricultures.
yes, madam.
For tax societies, there are 19 societies, Your Lordship, and the total amount comes to 53 lakh. We could not deposit because of the.
Wait. We will try to solve that problem, right? Your money won't go anywhere. Don't worry.
We are still having the experience, Your Lordship.
Keep it safe, na? Even if you give, nobody will accept. Why are you?
My locker has been attached by the SEBI, which was later detached by the SEBI order also. But after the due date of the depositing, the amount has been gone by. I have written to the RBI. They said 2 lines reply. Date has been ended and case from
Wait,
has been.
we will try to solve that. Huh? We will try to solve that. Yes, sir.
Your Lordship, I quite try to inhale as much agony as everybody has and try to find out a solution. And
to that 30,000 man, he wanted to argue. Where is
he will come at the end of the day.
He's there, he's there.
He may. Where is
There.
What is your submission? We have given you, allotted you 2 minutes.
IA number is, my lord,
Ah.
77219.
Come to the point. Come to the point.
My lord, there was procession fees of 30,000 lying in the file. So, but that SLP is still pending in the honorable court. It was changed later on, and there was no remedy except to put only the honorable court.
All right.
Only 30,000 is here.
We will consider. Yes, sir.
Your Lordship, I have my IA 13376 of 2020. I got a small amount of 1,98,000.
All right.
which I-
Wait. Keep it safe. Yes, sir.
Your Lordship, please. No, I tried to find out in the meanwhile, because large number of applications have been received.
Hello. May I submit, please, sir, Your Lordship?
Oh. Can I proceed further before my learned friend opens?
Mr. Sharma, we have said we will take your case at the end. Please wait.
Yes, Your Lordship, that's
All
what
right,
I
all
was
right. Yes,
remembering.
sir.
Thank you.
Yes, yes. All right.
So, we were trying to gather the number of applications which RBI has received. More than 700 odd applications.
Use the mic, I think, switch on.
More than 700 odd applications, I'm told.
700.
Under, to be considered under subsection 2. So many of them have been considered, and the RBI is not in a position to say, I'm able to accede to a request for acceptance. So unless I have a comprehensive, there are a large number of applications here, representation, whether they have been considered, what reasons given, I need to have a second look into them. I don't want to give a commitment. But one thing is that the government of India is very clear that they would not like to extend the window open for any further period, because then it introduces any amount of uncertainty in increasing the consideration point aspect of the RBI. That on that I'm very clear. But within those cases where RBI could do, if at all, on its satisfaction, whatever they may do, subject to a loss of direction, that's a different issue altogether. But the government of India is not going to say that we'll extend the date and thereafter applications will be received afresh. That will be an endless uncertainty, opening up the backdoor entry for again. Yes. So your lordship say. But I open up one exception, then Article 14, another exception, Article 14. Therefore, any number of those circumstances when people may have the bona fide background, but to say that we will have a series of exceptions granted to the extension of time will be certainly introducing an endless uncertainty. That will be going to be unmanageable. Then those who are otherwise knew that they could have done it now stand in the I'm told there are certain temple trusts who receive a lot of money and they want to get it in cash. So these are the kind of uncertainties which will come in.
Is a power vested in you under subsection 2 of section 4. And that power has to be exercised subject to your satisfaction. So if an element of satisfaction and discretion is vested with you, there is also a duty to decide it in accordance with law.
Correct. Let me.
Particular case is genuine or not. And even if you are in a genuine case, you are rejecting their claim, then it will be an arbitrary exercise of power. Answer it.
No, whether I would like to answer, of course.
No, not now.
Only one thing I would say, my lord, we have communicated that according to us, 4.2 is, my lord, in exercise of my lord, the power under 4.1.
Plain reading would not show that.
My lord, I'll try to, my lord, show you.
All right.
It's not a separate power.
Yes, attorney.
No, before we go into notification, there are two stages. I just lead quickly with the power coupled with the duty and all that submission. Well, if you are going to take away a property compulsorily, and there is no mechanism by which this acquisition is compensated, then what are that you are doing? So one may read a power coupled duty to ensure that there is an exchange provision available. That's available under the Act. There's an exchange provision available under the Act. Therefore, there is no acquisition of property at all. If the exchange provision has not been available in the Act, then Article 300A, all those issues will come.
Exchange provision up to a particular date.
That's right. Therefore, then comes the next question. Where do you draw a line? On that question of drawing a line, will there be an objective criteria, a racial criteria, or will be subject to any number of requests that may come from any number of quarters? It has to be some criteria on the basis of an understanding of the government to say that I am pushing this immediately for certain considerations and reasons, the object to be pursued. On that, I don't think there can be any controversy. You can choose a date 1 week later, 1 month later, or 1 week earlier. I don't think that consideration will ever fall for a judicial review issue. Large number of decisions have said that date will always have some exceptions here and there. Unless there is a pick and choose or a malafide. So I don't think we'll also get into that question.
Let us take a case of one of the petitioners, whose husband was in coma. He died after a cut-off date. And after his death, he recovered that such
therefore, those kind of cases, I understand that. Those kind of cases on the fringe, if I put it like that, if RBI has that reservoir of power under subsection 2, and a notification says we can do that, then it is entirely within the scope of the RBI. That's right. For I'm not discounting that at all. Maybe those cases will call what they call, even if you rule, sometimes a person may have an application for a deviation from the rule. In Rama Sugar Industries versus State of Andhra Pradesh, the Lordship said you may have a rule, a principle or a policy, but in a given circumstance, somebody may have a genuine application. The authority may have to oblige to consider the application. That's a different issue altogether. That may be read into subsection 2.
That is what we are saying.
That's right. Beyond that,
we are not asking you to extend the date under subsection 1 of section 4.
That's right. Therefore, that we are very, very clear. Lordship, the extension of date is certainly not a matter of a negotiation. That within that subsection 2 power, if those fringe cases can be considered subject to the satisfaction, so certain consideration will have to be fulfilled by the applicant. So it is entirely, your Lordship may add something to this, how the RBI may consider them, it's a different matter. I may not certainly restrict what can be done in order to complete.
We would also not like to open a Pandora's box.
That's right.
But if there are genuine cases, like Mr. Diwan's time,
there I may have something to say. and I have something to say.
Whether the reasons given are genuine or not, that is the subjective satisfaction of the RBI.
That's right.
We cannot sit in and appeal over that. But then they will have to take into consideration relevant factors and arrive at a subjective.
That can never be shut out. That question can never be shut out. But how they will exercise their consideration and what satisfaction they will arrive, except again the law is well settled. Satisfaction will be reasonable.
When is very reasonable?
It's a case to case. I as a government of India, I cannot say I will consider all the applications that happen.
Like somebody said that he had 3 crores of cash.
That's why I said that temples who receive large amount of donations that they want to come out. It is nobody's money, but then they will claim. So black money coming in this kind of,
That's all. Therefore, the language employed in that 4.2 is subjective satisfaction. Read that provision.
If satisfied.
If satisfied. So it is for them to take a call, It is for them to take.
If satisfied.
If satisfied. These expressions are
and genuine.
That's right. If satisfied would include genuineness.
Yeah, satisfaction also is not left to their own whims and fancy.
Your Lordship knows satisfied has received his judicial concession, well known, satisfaction to the reasonable, fair and just and all that.
But when you made the notification for cooperative societies in June 2017, it must have been exercise of power under section 4(1) Roman 2. Because it says such class of persons.
Such class of persons. That's right. Therefore, it was.
Under which provision you did it? It must have been under 4(1) Roman 2.
Such class, that is a widely word, such class of person.
Yes. So you have done it for a particular class of persons.
Correct. So
that's not under subsection 2. That is under
subsection
4(1) Roman 2.
Subsection 2 comes later.
Yes.
That's right.
No, but you have done it.
That's right. I'm not saying there is a notification.
And you did it 6 months later. In 2017.
Notification, you're not right. Notification takes care of non-residents, residents,
No.
non-residents.
For
That's why they are
for co-op
subsequent notifications.
So that must have been exercise of power under 4.1 Roman 2.
That's true. There's no difficulty about that.
Yes.
But after such a notification, whether RBI will come in, that will come in only under subsection 2. That's a different issue altogether. The two stages are different.
No, that,
suppose I'm not.
Notification itself came beyond 31st December, beyond March, etc.
I'll take another case like this. Suppose there was a class of persons who would otherwise be entitled to make an application, and I have not issued a notification covering them. Somebody may have a case against that. That's a different issue. But here we don't have those issues at all. It's only a question of subsection 2, satisfaction of RBI and how they can go about fulfilling this duty.
So prima facie, you agree with your submission on that?
I'm only saying there is a statutory avenue open and the statutory avenue will be exercised. I'm not making any concession on that because there is a statutory avenue available. And only it's hoped, since all is getting brought before the court and the court has also expressed its concern, of course, the exercise of power under subsection 2 will be.
What is your answer to the main submission on exercise of powers under subsection 2 of section 1?
I'll presently address that question, section 26 too, because I have some other submissions.
That is the main legal issue.
I have some submissions to make before I come to that question. There are 3 sets of affidavits filed by the Union of India over a period of time. And tracing the history over a period of from 2014 onwards, what is this application of mine and material studies, surveys conducted, so on and so forth. And we also put on record in the current affidavit the connection between demonetization, the tangible, intangible, direct, indirect benefits. How do you get it connected? And the Union of India says don't look at demonetization in isolation. It is not a standalone measure. You don't look at it only in exercise of power under 26(2) and don't reduce it to that issue. It is a larger ramification. And how do you connect it? I'll try to address your lordship on that. Then the second aspect is, look at the role of a central bank. Central banks all over the world, from 1642 central bank alone. You look at the trajectory of their role, functions, etc. Broadly, a monetary policy. And the monetary policy, again, is not to be, again, looked at as a monetary policy which can be dealt with without being connected to the economic policy of the country. So they're also intrinsically connected. So in the evolution of monetary policy and the operation of monetary policy, we have, again, in current standards, I was just reading a book written by the one-time governor of the Central Bank, Federal Bank of USA. So look at the growth trajectory of the function, the inflation control, inflation management, in monetary policy, interest rate, cutting interest rate, enhancing interest rate, so many things which come in the entire gamut of this monetary policy. Therefore, you can't probably define within a very close limits. The bank will have to operate only in this manner. Capped and confined, you can't do that. So this is how the functions of RBI may have to look into. Having said that, kindly take copies of the written notes for the book. Lords, may kindly take, may quickly take my written notes.
Where is it? Written notes.
I gave it today. Gave it just now.
Chief के यहाँ कौन
Yes. The impure notification is of the year 2016. The process of exchange of notes and connected matters, including extensions consequent upon the issuance of the notification, were broadly over and completed in due course. The Honorable Court framed the issues for consideration by a constitution bench order to The focus was thus on the content of the notification, its effect and impact on certain constitutional rights. The questions so framed were thus contextual. Notification has since merged with the Specified Banknotes Ordinance 2016 and subsequently with an Act of Parliament, namely so-and-so. There has been no effective challenge in a writ petition to the Provisions Act during 2017-18. However, challenges were made in the application seeking intervention bearing number so-and-so, including one now filed in 2022. It may not be appropriate to deal with the challenges of the notification when it merged in an Act of Parliament. Challenge to the notification cannot become challenges to the Act. It is submitted the notifications giving effect to what is known as a demonetization policy is a policy measure of pure economic measures. Emanating from Section 23 RBA Act 1934, it's a monetary policy. The 2017 Act is a further measure of monetary policy, as was the High Denomination Banknote Act 1978. Several matters of fact set out in the writ petition and affidavits filed by the petitioner relate to the sequence of events following issuance of the notification. Some petitioners have given that regardless of assurance regarding facilitating exchange of denomination, they have not been able to get the exchanges done. Submitted between 2016 and 2022, several significant developments have taken place in the national economic policy and measures. Having regard to the diminution or cessation of the effect or impacts asserted in the petition, following the notification and significant major economic development, the need and relevance of engaging in the judicial scrutiny of the notification and its impact has become moot. In view of the settled position that matters of economic policy, the court will be slow to enter into the scrutiny process and will defer to the wisdom of the policymaker, both in its substantive and procedural aspect. The court may not be persuaded at this point in time to engage in any detailed scrutiny of any aspect of the matter. It is equally well settled that when the relevance of a scrutiny disappears, the court will not render opinions which are of academic value. The court will not grant declarations in the abstract or via guidance when no tangible relief or a remedy can be effectively granted by way of putting the clock back, which is called uncrambling the scrambled egg. It should be kept in mind that the asserted impacts on individuals are not of enduring or continuing nature, but they have come to an end. Subsisting grievances, if any, are matters that were dealt with through the executive measure. In other words, there is no continuing wrong which warrants engagement by the court. Having regard to the nature and complexity of the policy dimensions of the matter, it is desirable to consider the threshold questions based on the aforesaid well-settled principles, namely, there must be a judicial deference to the state in matters of economic policy and economic legislation. Courts have universally accepted that there must be such deference in matters of economic policy on the following compelling reasons. 1, commitment to the constitutional separation of powers. 2, lack of institutional competence to the courts and complex economic matters on which even experts may differ, and inherent difficulties in formulating judicially administrable standards. And 3, committee between the 3 organs of the state. B, all matters relating to the procedures or the processes adopted in the notification, whether deserving of judicial consideration or not, cannot be invoked for deliberation indirectly for the purpose of entering into the wisdom of economic policy and the relevant attendant measures. The court cannot be called upon to render decision on the question between inaction or perfection in the sphere of economic policy and legislation. The court will not render decision declarations into moot or academic questions, and where particularly no tangible relief with reference to alleged procedural unreasonableness can be meaningfully granted. Questions 2, 3, 4, and 5, framed in the order dated 16/12/2016, would require a pervasive analysis of the entire policy behind the notification and its implementation, and consequent rendering of opinions based on policy evaluation, which the court will not be inclined to do. Necessarily, question numbers 1 and 6, which are entangled with the above questions, may also not be gone into, and for mere grant of declarations in the abstract. The submission that the notification question has failed in its stated objectives while causing undue hardship is misconceived. The aspect of realization of the stated objectives is best understood by considering the legal tender cessation measure not in isolation, but by looking at the direct and indirect, the tangible and intangible benefits flowing from such a measure. The requisite factual background to show the larger steps and movements in the economic framework has been set out in the affidavits filed by the Union of India. Seen from the perspective of larger social and economic benefits, it can be hardly canvassed that the demonetization measure has failed. This being the correct perspective taken, the scope for scanning or scrutinizing the reasonableness of the measure can hardly exist. Having regard to the scheme of section 3, 7, 20, 22, 23, 24, 25, 26, and 34, all of which are important facets of a currency management and monetary policy, and all of which deserve a free play in their joints, and can ill afford rigid or inflexible guidelines in their operations, it may not be appropriate that these provisions are subject to such canalization measures. It's submitted that the very nature of the subjects and matters to be dealt with under the scheme of the above said provisions demand a time-to-time flexibility, and in the absence of such flexibility, the creative ability to act under these provisions will be stultified. Submitted that while considering the stated objectives set out in the notification, Union of India has also addressed the question of putting into place such measures and steps as may, to the extent possible, reduce the inconvenience and hardship by reason of the withdrawal of legal tender. The measures in regard to the exchange have been designed wide enough to address this question. The enormity and immensity of the task, being a challenging task, could obviously involve improvements, calibrations, and additional set of measures, which are put in position from time to time with as much dispatch as possible. Details in regard are set out in the affidavits. The larger benefits that have flown into the economic system by reason of several set of measures, on the one hand, and the one-time hardship that the people have faced are incomparable. The former cannot be negated as of no value by reason of such comparison. The question of comparison between two alternatives for effectuating a legitimate aim can arise if the alternatives are capable of being compared. As long as the legitimate aim and the means sought to be invoked is not alien to the legitimate aim or unconnected to the legitimate aim, the method chosen or principles adopted for the invocation of the means cannot be put to test in the above circumstances. In other words, having regard to the hugely complex subject of national monetary policy and the hugely complex aspects of black money and fake currency, which will demand combination of several means, methods, and adaptations, there can be hardly any room for the proportionality principle. The notification has worked itself out. The question of prospective overruling will arise only when the future operation of a questionable statute may demand an arrest. Section 26(2) by itself is not in continuing infringement of any rights. Prospective overruling cannot be invoked to injunct future operation of Section 26(2). Consequently, there is no room for reading it down. Additionally, no measure or guideline by way of reading it down can be brought into the scheme of Section 26(2). The construction placed upon Section 26(2) touching upon the words any series is misconceived. The focal point of Section 26(2) is the denomination to be dealt with, and the matter of series of notes will follow only after the subject of denominations are dealt with. Once the denominations to be dealt with are decided, the best way to avoid hardships and inconvenience is to include within the demonetization measure all series connected to a particular denomination. Even if two views are possible on this matter, the view which will advance the scheme of Section 26(2) as a whole read with Section 3 of the Act, namely the management of currency, will be preferred. Since the Parliament has enacted the overarching law of specified so and so, etc., the need for entering into Section 26(2) interpretation does not arise. Yeah. Okay. Very soon. I've culled out from various affidavits for the purpose of your lordship's convenience. One broad submission I'd like to make is the kind of data statistics regarding notes in circulation and fake currency, etc., will be a broad guidance. The court will not take a microscope and say, look here, what is this figure missing? Is a figure wrong? Is a figure doubtful, etc.? So that perhaps will not be undertaken by the court. What I am trying to give from the various affidavits is the direct benefits from as far as reduction of fake currency. As per the newspaper reports, the measure resulted in the destruction of the fake currency in the hands of the holders. This amount is difficult to quantify. The holders of counterfeit notes were thus stopped from continuing to put the fake currency into circulation. Total number of counterfeit notes in circulation decreased sharply post-withdrawal of legal status specified banknotes from 7.62 lakh notes in 2016-17 to drop to 90,000 notes in September 2021. So you can't say, look, the notification came in November, it should have happened immediately thereafter. There's no calibration to do that. Then counterfeit currency dedicated in the banking system is reported by RBI is currently detected in the banking system. Other law enforcement agencies also provide values of seized banknotes. Overall, the exact magnitude of fake currency could have been much higher than reported. The overall trend indicates that demonetization extricated the fake currency significantly from the system. Is this not a value which the court will definitely address while looking at the measures taken by the government over a period of time? So the extricating is very important. The quantum of extrication may not be so important. Because that's again a huge thing outside the hands of any planning authority or their governance. The enemy is standing outside grinning at us. I can play with you because fake currency and black money are such enemies you can't easily identify and put your hands on. They wear masks all the time. Therefore, it's easy to say that look at rational standards, how much you have detected, how much money has come into the banking circulation. All that questions will better answer by saying, look at the complexity of those who are waiting outside the formal economy and trying to render the formal economy and then derail it. So these are the concerns government will take into consideration. Let me read further. Significant pickup in the fake so-and-so detections reported in the banking system, as I say, pointed out. 2015-16, preceding withdrawal of legal tender, 6.3 lakh pieces. Then 2016, it was detected to be 7.6 lakh pieces. After withdrawal of the legal tender status of so-and-so, steady and significant decreasing trend in the fake currency detections reported by RBI. So you look at 2020 when it is 2.1 lakh pieces. In terms of value of counterfeit currency, 43.47 crores of notes were detected in so-and-so, which progressively reduced to 5.5 crores in 2020-21.
Only submission you have made counter to the other side is these are all economic policies, don't touch. That's all so far you have said. What is your legal
I'm only trying to find out why
that's all right. What is your opposition to the plea of the other side? Please tell us. Your only submission, as we understand from this, this first submission notice.
Yes.
These are all economic policy. Experts have done it. Don't touch. That's all.
That's a broad proposition.
Then tell us. You point out you must. What is your argument? How do you counter their submission?
No,
for example, they said it is not in conformity with section 26(2).
Come to section 26. I immediately come to it. I just come to it.
That is the main argument they have canvassed. That is perhaps
the argument on 26(2) is premised
how you have
on certain framework of facts.
That's all right. What point you meet the points one by one.
Your now argument appears to be since we have now enacted a 2017 Act, don't touch our action under 26(2).
The notification, I think it's a very legitimate legal argument. The 2017 Act has come into position. I'll read the 2017 Act, section 3 and 4.
No, maybe this what you have now given is almost to say that the object has been achieved kind of thing. First you should show the contention which was heard, whether the procedure was followed rightly or not.
I'll definitely come to that. I'm not going to skirt that issue at all. The procedure to be followed, I'll share the information also, nothing to hide from the court, everything is clear. But I want to lay down a foundation for what is thought to be said. How do you look at section 26? If you want to look at section 26 as an standalone provision and as any other statutory provision, then we are probably going in a wrong direction. I want to say, see the scheme of the RBI Act. Look at 26. What is the place which occupies in the entire RBI scheme of the powers and function given to RBI? Unless we look at that, 26 will not probably get its proper light and in construction. Therefore, I am trying to place all this background to show how do we really look at it. I'll certainly come back to section 26 in a few minutes. And if may then read this note a little later.
No, we will leave it to you, but please answer their question.
I'll definitely.
Please respond to what is.
Let's then take section 26 for a minute and the RBI Act. before may then complete reading this note which I had given and then come. My broad submission on section 26 would be look at the entire scheme of a string of provisions in the Reserve Bank of India Act and what's the role of a central bank and how it discharges its functions and what amount of responsibility it is called upon to act under section 26. And if you want to introduce certain pedestrian considerations on looking at an ordinary statute, either a recommendation, either a consideration, either a consultation, well, then you are going to reduce section 26 to a very narrow area where the entire complexity of management of currency monetary policy will be stultified. That's why I thought I'll place a larger framework and then come to section 23.
No, we are looking.
I'm sure I'll be able to pursue lots of the way section 26 should be read and understood in order that the integrity and the scheme of the RBI is kept intact. We are talking about an important legislation for the entire monetary policy of the country. It is not any other statute. Therefore, certain considerations may have and invoke for the purpose of reading any other statute, giving a little flexibility, liberal reading, purposefully, etc., may not be helpful in the context of a statute like that.
No, we are looking at section 26 in the context of central banking functions, chapter 3. It is a central banking function with regard to section 26.
कौन सा चल रहा है? 47 तो निकल गया ना,
34 चल रहा है अभी.
वहीं पर.
I was yes. In the second page of this note. Yes. In case of high denomination banknotes 500 to 1,000, counterfeit currency is worth 16 crores detected in so and so, which reduced to 1.98 crores in 2020-21. I'm reading the second page at the top. Yes. And as per National Crime Records Bureau report, seized currency of high denomination banknotes so and so decreased significantly from face value rupees 14.86 crores to 6.5 crores in 2019. It's a very significant reduce. Then search and seizure actions for unaccounted assets and wealth. When I say direct benefit, the direct benefit of demonetization. The earlier parts of the affidavit contains various data mostly covering up the period 2018. It's added to this section. Between 1st April 2017 and 30th September 2020, Income Tax Department conducted search actions in so and so cases, leading to during the period from April 2017 and August 2020, surveys were conducted in 41,000 zones where undisclosed income of 40,188 crores were deducted. The trail of deposits of demonetized banknotes into bank accounts has provided valuable information to the revenue authority to tracing unaccounted money. During the period between 2016 to March 2017, the Income Tax Department seized around rupees 900 crores, including cash rupees so and so, and admission of undisclosed income rupees so and so crores, 7,961 crores. Further, during the period 1/4/2017 so and so, undisclosed assets worth rupees so and so crores seized and 57,000 crores admitted. During November 2016 to March 2017, A total of 8,239 surveys were conducted, leading to detection of undisclosed income of rupees 6,045 crores. Subsequently, in the period from 1/4/2007 to 31/8/2022, surveys were conducted in 43,431 cases, wherein undisclosed income of rupees 59,090 crores. Various measures were taken to suspected depositors, non-filers who had deposited large value of cash demonetization period, and regular email and SML were sent to the taxpayers for submitting online response. These exercises promoted compliance, which resulted in increase of income tax returns for filter-based and direct tax collections also. Then indirect benefit. By the end of September 2020, notices issued in case of undisclosed foreign assets and income over 14,150 crores. Action against domestic black money between April 2014 and September 2020 resulted in undisclosed income of 82,168 crores as admitted. Surveys conducted in 63,691 cases led to undisclosed income of 84,390 crores getting deducted. Prosecutions filed in so-and-so cases, 9,000 have been compounded and 327% gets convicted. Then, look at the improved tax revenue collection, the income tax returns. The direct benefits. We have an improved income tax IT return, significant increase in new IT filers. You look at 2013-14, we have a 4.19 IT filers, 14-15, 4.45, 15-16, 4.87. Now 16-17, 5.45. You from 2016-17, 17-18, 18-19, a huge jump from 6%, 9% to 12%, 15%, 14%. A very important, significant increase. And that's an indirect benefit. Then we look at then 2021-22, of course, this is lockdown period. For that, there's a dip. The number two, significant increase in number of taxpayers. In 2016-17, total taxpayers were 8.35 crores compared to 7.47 crores in 2015-16, indicating an addition of 87 lakh new taxpayers. Later, I will show about the employment position, how EPS, employment, ESI, etc. There is an increasing, contribution. Now, 2014-15, you have 6%. So only mark 2016-17, 17-18, 18-19, the increase in the number of taxpayers. And this is a very significant increase. Then 25% growth in income tax returns filed during 17-18, 6.27 crores in 2017-18, as compared to 5.4 crore in 2016-17. Then significant increase in returns filed by corporate taxpayers, growth rate of 17.2% for corporate taxpayers, so and so, more than 5 times higher than the growth rate and so and so. Then substantial number, a very equally important issue. A substantial growth in new PAN numbers during financial years 2016-17. 4.65 crore PAN number allotted, which is 87.9% higher than 2.74 crore PAN numbers allocated during the financial year 2015-16. So that's how indicated in this table. Then thereafter, paragraph 2, enhanced tax collections. Net direct tax collections were significantly higher. Growth rate of 18% for FY 2017 is net direct tax collection over FY 2016-17. Then rise in personal income tax. Personal income tax advanced tax collections increased by 23.4%, and for PAT self-assessment by 29.2% over those so and so. So self-assessment tax in witnessed steep increase, almost doubling a span of 2 years. So 17-18, we have about 1 lakh crores. Then enhancing the digital penetration. We all of us know from moving from an informal economy into a formal economy requires various set of measures. So we are talking about the digital economy and the digital penetration. Direct benefits. Unified Payments Interface launched in 2016 saw transactions worth 6,952 crores in so and so, which rose to 1.09 lakh crore, 8.7 lakh crore, and 21 lakh crore to the next 3 years, 17-18, 18-19, 19-20 respectively. The monthly transaction crossed the 2 billion mark in UPI in October 2020, recording an 80% growth in volume and 10% increase in transaction volume, so and so. Greater digital penetration has been one of the most tangible benefits of withdrawal of legal tender status of SBNs. The volume number of UPI transactions shot up from 1.6 crores in 2017 to 90.5 crores in 17-18, and further about 5,000 crore in 21-22. The value of the UPI transaction also grew 1,210 times compared to 2016-17. And what are the indirect benefits? Digitalization, along with demonetization, makes electronic payment mechanism viable, available, acceptable, and cost-effective. Contactless cards and mobile payments are broadening the base of digital payment mechanism and penetrating into smaller transactions, including one-on-one person-to-person payments. The internet banking model and mobile banking model through smartphones have increased, keeping pace with the rapid digitalization of India. Then we turn over to the next page. Less cash economy, direct benefits. The withdrawal of legal status of SBN resulted in lesser cash-based economy. The note ban slowed the growth of cash. 16.1 lakh crores worth of notes were in circulation at the end of the financial year 2015-16, registering a year-on-year growth of 14.51% over 2014-15. At this rate, note circulation would have increased 29.49 lakh crore by the end of 2019-20, whereas it increased only to 24.20 lakh crores by the end of 2019-20, thus reducing incremental growth in currency in circulation by over 4.28 lakh crores. Demonetization brought cash to GDP to 8.7% in 2016-17 from 12.1 in 2015-16. The next one, impact on banking and economic variables. In spite of demonetization, following parameters had remained stable: investment, common spending, exchange rates, interest rates, and money supply. And when global economy was suffering from an overall subdued demand, India, despite an initial slowdown in growth following demonetization, managed to maintain above average growth rate level, and there has been a rebound later both in the manufacturing and agricultural output. Demonetization has brought significant impact on banking variable. Sudden surge in the liquidity brought down the interest rates, affecting asset quality. Domestic credit picked up a new high since July 2017. Non-food credit recorded an upward trend in November 2016, witnessing an 8.8% growth till November 2017 on a year-to-year basis. Demand and time deposits have been increasing since demonetization. The real GDP growth in 2017-18 was higher than the average annual growth of 6.6% in the decade, that is 2010-11 to 2019-20. Then formalization of economy, indirect benefit. Between September 2017 and November 2018, Employees Provident Fund Organization enrollment data saw an increase of 1.1 crore new enrollment. That means there's an upsurge in employment. And 55% increase in ESIC registration took place in the Employee State Insurance Corporation in 2017-18. Then indirect benefits, the last page, improved status of India in the global stage. By the end of September 2020, notices were issued in case of undisclosed foreign assets and income over 14,150 crores. Action against domestic black money between April 2014 to September 2020 resulted in undisclosed income of 82,168 crores as admitted. Surveys conducted in 63,000 so-and-so cases led to undisclosed income of 84,396 crores getting deducted. Prosecution so-and-so. Therefore, the global reputation of India has gone up enormously, poses cleanup measure and the transformation of the economy. This is a broad picture I wanted to look, your lordship, to have it. And then having that in mind, then we will probably look at the scheme of RBI Act. We'll get an entirely different perspective on that. I have tried to summarize all it in a disturbed date format. Your lordships can convenience can you hand it over. I don't propose to read it, I'll call just. Out of a very special scheme and a special act. Therefore, the deference, the degree of deference, and the understanding and the construction of the provisions of this act will vary far different from the other economic policy measures. We're not looking at an isolated economic policy. We're looking at a monetary policy which will be the birth product of an action taken in Section 26. Therefore, entirely different considerations will follow. and the degree of deference will certainly be a higher level. Now, having said that, let's clear Lordships to section the RBA Act. This the bank is of 1934, pre-colonial. Look at the preamble of the Act. Whereas it is expedient to constitute Reserve Bank of India to regulate the issue of bank notes and the keeping of reserves with a view to securing monetary stability in India and generally to operate the currency and credit system of the country to its advantage. And whereas it is essential to a monetary policy framework to meet the challenge of an increasingly complex economy, whereas the primary objective of the monetary policy is to maintain price stability while keeping in mind the objective of growth. And whereas the monetary policy framework in India shall be operated by the Bank of India. I just look at the preamble. How do you gather thoughts around the economic thoughts behind this whole preamble? The economic thoughts is an experience. Now this, the second and third, all that came in by Act of 2016. And whereas essential to a modern monetary policy and primary objective is to maintain price stability, all that came in the year 2016. There's a understanding that has evolved out of how the Reserve Bank of India's role in monetary policy over a period of time, not only domestically, across the globe. Therefore, that information, that knowledge is gathered in this preamble. I am trying to look at each one of those. A modern monetary policy framework to meet the challenge of an increasingly complex economy. So we're not looking at some black money here and there, some fake currency here and there, trying to avoid being detected. We are trying to look at the larger picture of how do you manage a complex, challenging monetary policy today. So in that context, if it happens that these irritants on the way, these impediments on the way, derail the monetary policy itself, what will be the nature, the extent, the degree of derailment? That is absolutely irrelevant. The only arguments was that, look here, you're completely failed in the three stated objectives. So therefore, your policy perspective is completely wrong. I don't think any right-meaning person will say that because of the best intentions, you still fail, your intentions are also faulty. I don't think that logical connection ever be made. Therefore, it's important to look at each and every phrase which is contained in the preamble. So let me take your lordships to what happened in 1934. Please come to section 3. This section 3 reminds on the statute book from 1934. A bank to be called the Reserve Bank of India shall be constituted for the purpose of taking over the management of the currency from the central government and of carrying on the business of banking in accordance with the provisions of this Act. Currency management is a reserve of the Reserve Bank of India. And what is the currency management? We'll go as along, we'll find out what exactly are those aspects of facets of currency management. Kindly turn to...
What is their main submission, Learned Attorney? According to them, everything that has to be done with regard to currency.
Yes.
It's a primary duty of the RBI. And therefore, subsection 2 of section 26 requires that the proposal should have come from the RBI.
I'll currently come to it. I'm only trying to lay down.
There is no dispute with the proposition that RBI has a primary role insofar as management of currency is concerned.
No, there's no dispute about it. RBI has the currency.
They are also on the same.
No, their perspective is, argument is slightly different. RBI must apply its mind completely. No outside dictation. Government shall have no role to play in that. If RBI has not applied its mind, survey, data, this, that, etc., nothing is there. Where is the application of mind? Where is the recommendation? So I'm only trying to point out, look at it little closely. The connection between, having regard to the composition of RBI, the connection between the working of the government and the RBI must be seen from a very flexible point of view. It is not a case where RBI in its functions is impeded by an outside agency like the Government of India saying, don't do this, then it's a different matter altogether. So we are looking at the necessary symbiotic connection between the government and the RBI. We're looking at this very complex issue of moving towards a modern economy and a very stable monetary policy. Despite trying to have the best of a stable monetary policy, every year lordships know budgets comes and go. And we always challenge about budgets. People have questions about budgets. The failed budgets, successful budgets, so on and so forth. Therefore, we don't say failed budget means somebody had not applied his mind. So we don't say all that. Therefore, we are looking at the symbiotic connection between the government and the RBI. If you want to sever them and put them in compartments in isolation and say that RBI must first apply its mind, never in touch with Government of India, never in consultation or having any correspondence, but must do his own job, then come and tell government, look here, I have a recommendation, will you consider that? I think I have a small difficulty in that construction. That's why I'm trying to take lordship. Look at the complexity of the power now imposed on the functions of discharge of the RBI under this very challenging circumstances. That's why you said don't give it a cribbed, capped and confined construction. Give it a very flexible construction, a wide construction.
No,
now let me take lordships further on that and
the argument was,
I'm sorry.
Mr. Attorney General, the argument was that the Act recognizes the expertise of the persons in the RBI. And it is that expertise which must recommend to the central government. The Act recognizes that. Central government, we are not saying is bound by that recommendation or not bound by that recommendation. We are not at that. We are at the position of where it should emanate. No doubt there must be symbiotic relationship, all that is there. But the legislation is not like that. Legislation recognizes the expertise of the Reserve Bank board, the application of mind by the central board to the central government. The argument is, where is that?
My argument is not that RBI's role has to be minimized. It doesn't have that kind of role. Its application of mind is of no consequence. I'm not saying that. I'm only trying to appeal to look at that's why I use the word symbiotic connection. It's a very organic connection between government and RBI.
They have to work in sync with each other.
That's I think very important. You don't say, I'll sit in my own chamber, unconnected with you, or I will not listen to you at all. I will not lend my ears to you. And I don't think that's the way in current contemporary times. Your monetary policy, its evolution, its integrity, its cohesion, all that will have to be kept in mind. Therefore, that's why I tried to lay this very broad framework, and that's very important consideration. Now, kindly turn to page 7, section 7. The central government may, from time to time, give such directions to the bank as it may, after consultation with the governor or the bank, considered necessary in the public interest. Subject to such any such directions, the general superintendent in direction of the affairs and business of the bank shall be entrusted to a central board of directors, exercise all powers and do all acts, things which be exercised by done by the bank. So and so, provided regulation made by the central board, the governor shall have so and so nominated powers of general superintendent. This power to give directions probably will find in many statutes where the central government or a state government can always give directions to an authority, statutory authority. But it also occupies a slightly different connotation from what I propose to do. Then kindly turn to now section 17. These are the kinds of business with the bank shall be authorized to carry on and transact the several kinds of businesses hereinafter specified namely. And we'll also look at the kind of businesses which have been added over a period of time. They are very valuable additions. And maybe if you look at it very closely, some of them seem to be unconnected, but they have a certain connection. So the functions of the bank which have increased over a period of time are also on the basis of the experience gained at what important role a central bank will play in the national economy. Without taking a lot of those detailed provisions, kindly now turn over to chapter 3, section 20. The bank shall undertake to accept monies for account of the central government and to make payments up to the amount standing to the credit to the account and to carry out its exchange, remittance, and other banking operations, including the management of the public debt of the union. That's where 20, 22, 34, etc. may come. Then kindly turn over to section 22. The bank shall have the sole right to issue banknotes in India, may for the period which shall be fixed by the central government on the recommendations of the central board, issue currency notes of the government of India, supply to it the central government, and the provisions of the act applicable to banknotes shall unless so and so apply to all currency notes of the government of India, issued to the central government or by the bank like manner, as if such currency notes or banknotes and reference also shall be construed accordingly. Then 23, issue department. The issue of the banknote shall be conducted by the bank and issue department, which shall be separated and kept wholly distinct from the banking department. And the assets of the issue department shall not be subject to any liability or the liabilities of the issue department defined in section 34. Then kindly turn to section 24. Subject to the provisions of subsection 2, banknotes shall be of denominational values of 2 rupees, 5 rupees, 10 rupees, 20, 50, 100, 500, so on and so forth, not exceeding 10,000 rupees that the central government may, on the recommendation of the central board, specify in this behalf. The central government may, on the recommendation of the central board, direct the non-issue or the discontinuance of issue of banknotes of such denominational value as it may specify in this behalf. These are conceptually different from section 26. Then 26. Subject to the provisions of subsection 2, every banknote shall be the legal tender at any place in India in payment on account for the amount expressed therein and shall be guaranteed by the central government. For two concepts, it shall be legal tender and guaranteed by the central government. If in the absence of section 26(1), so the question of banknotes and their legal tender will not arise. Therefore, here is the most important provision in the RBI Act. Then having given the power to issue banknotes, should it stop there? So should it leave to an imagination or to an unoccupied field for the RBI to deal with? Once you have issued banknotes, what do I deal with them? If I want to deal with them later at any point of time, having regard to the monetary policy demands. So subsection 2 is very important. On the recommendations of the central board, the central government may by notification the Gazette of India declare that with effect from such date, as may be specified in the notification, any series of banknotes of any denomination. It is the importance is not on the series, the importance is on the denominations. What would I look at? I create denominations 10, 20, 30, 500, 1,000. Those denominations will now become legal tender. And with those denominations, for every denomination, there is a series of notes. For every denomination, there is a series of notes.
It is presented by any series of.
That's right. My submission is the focus of this provision is not necessarily exclusively on a series. It is on denominations. Denominations are the value. Series are only the presentations. So denomination is what I'm going to account when looking with the legal.
For 10 minutes, 3 minutes, he'll do it. He does not understand the nature. She herself is a doctor. He doesn't. She is there.
We haven't found that there is
Uncertainty. Therefore, I look at the denomination, and whatever be the series in denomination, I want to look at it totally.
No, it is not supposed to be done on a day-to-day basis,
It should not be done. It's
not to be done on a day-to-day basis. That is why the
look at the uncertainty for me. For every citizen, if I am going to say 500 rupees denomination, I am going to cease to be legal tender. But tomorrow I will notify 10 series. Day after tomorrow I will notify 8 another series. Will there not be an endless uncertainty and chaos? It will be. Therefore, in order to ensure that there is a guarantee of comfort, I am looking at one denomination. I must necessarily bring within it all series possible. Otherwise, it will be endless uncertainty in favor. Therefore, the way you construe it is not the reference to series, but the reference to denominations.
But then immediately after you bring into both the notes of same denomination on the very next day.
Yes.
If you, according to the focus is only on denominations, you withdraw all 500 rupees notes, and then on the same day again start new series of 500 notes.
No, that's a different issue altogether.
No, if you're
That's a different
that
issue.
you have to focus only on denomination.
That's a different.
That argument runs contrary to what you are telling.
I only my first argument is, how do you really look at section 26.2? We have been told, focus your attention on series, any series. I say, I'm sorry, it's wrong. Focus is, when you wanting to have something to be ceased to have legal tender, you are looking at denomination. Because the bank denomination of notes is what is section 24 talking about.
That is exactly the question which
Yes.
my lord just now said. The very next day, you resurrected the same denominations,
No.
500 and.
I'll address that question. I'm only trying to say, how do you address this? How do you construe section 26? And the question very next day, I said this, I did that. He said, he is so connected with the monetary policy, a demonetization will be a series of issues. I'll come to that. But I'm only trying to tell you, Lordships, the only way to read section 26.2 is to focus on what will you do when you want to say, I want this shall cease to be legal tender. My first step is I'm looking at the denominations.
No, probably that argument may help if you want to demonetize all 1 rupee notes, because they are par and not. If you want to demonetize all 1 rupee currency, maybe this argument can be accepted, because that is of really no value in today's world. Your argument could be possibly for 1 rupee, 2 rupee currency, but not for 500 and 1000.
May I address this question also? The question of which denomination shall be chosen will again be a matter of policy considerations of why I am choosing. In the 1978 case, in the parliamentary debate, what happened was, they also 500 rupees and 1000 rupee notes. In the parliament, somebody went and said, why are you not looking at 100 rupee notes? They are hugely in circulation.
Notes.
78. So therefore, we are looking at, if you want to looking at one, a shift in the monetary policy from all these perspectives which I placed before your lordships. Number one. And number two, how do you, whatsoever you may do, howsoever you might endeavor to do. As I said, these two villains sitting outside, black money and fake currency, they grin at you. You can't reach them as much as you want. And therefore, you may fail. Therefore, the measure is not an, somebody will sit outside and grin at you, you fail. Therefore, why you are going on demonetization? Therefore, very loudly it is suggested you must have a specific survey, a data, this and that. We are talking about a nation's economy. We are talking about nation's economy and meeting challenges and how to deal with these outside enemies, which always, for instance, today, we are state actors outside. We don't know how much fake currency can come at any point of time. Derailing national economy has been happening in Germany during the Second World War. The only way they tried to destabilize the economy was to flush in fake currencies in other European countries. Therefore, it's a very easy thing to be done. Can we detect them with a small microscope or a glass somewhere? We can't. Therefore, we're looking at the larger picture. So please don't reduce section 26 to a very narrow area, 1 rupee, 10 rupee, 20 rupees, 5 rupees. No, please don't do that. Now let me read further. Yes. So an argument was made that look here, after demonetization, there was easy to detect the new. Your Lordship, I'm so sorry. I'm sorry, I'm taking Lordship time.
The language employed in section 26(2) is
yes.
Any series, where is it?
Of bank,
any series of banknotes of any denomination shall cease. Now, what have you demonetized here? All 500 and 1000.
Like they are the denominations.
Of 500 and
1,000 is the denomination, 1000 is the denomination.
Yes, no, we will go step by step.
I'm sorry.
Now, the argument of Mr. Chidambaram is,
yes,
any does not mean all. Please listen to us.
Yes.
Therefore, according to him, you could not have, for example, 500 rupee denomination notes. It has two series. For example, he said just 2 weeks prior to the date of denomination, you have issued currency notes. They were also demonetized after 2 weeks. Therefore, there were two series, Mahatma Gandhi G series and Mahatma Gandhi series, right?
All right.
There are. Now he says, you could not have done both the series. Therefore, the pointed question to is whether any includes all. That's all you have to argue.
No, that meaning
Please
any
tell us.
includes-
Come to
any
the point.
include-
Come
I'm
to
sorry.
the point.
Any includes all will necessarily flow.
Therefore,
will necessarily.
what does the dictionary Ramanath Iyer say? The word meaning of any.
That's right.
What does it say? Or Black's Law Dictionary take up.
Any includes all will necessarily flow.
That's all right. Let's just see, for better appreciation of this, we will read the continue.
Yes.
So the pointed argument is any series of banknotes of any denomination shall cease. Therefore, any, you have demonetized all of 500 and 1,000 denominations.
No. Let's one minute. I will make small.
Tell us.
The
Focus your argument.
denominations in section 24 are very denomination. From 10 to 2,000, 10,000. These are the denominations. So any one of the denomination, any means any one of the denomination, 500, 1,000, 2,000. That's what any denomination means.
Yes.
Depending upon.
Word any series, that series has to be rendered OTOs.
No, it won't be rendered OTOs.
So any denomination.
It won't be.
So
Where it is necessary.
That is
Where it is necessary in a given context.
any.
In a given context where you're not, let us keep a demonetization issue altogether.
Well, word used any is twice. Any series, any denomination.
Why is it, I'm asking a question, why is it used? So therefore, in both places, either any should receive a common meaning for both the expression, or it may have different meanings also, depending on the context.
No, if-
The exercise of power in a given case.
If your argument is to be tested
Your
at
Lordship.
any means all, that means you can demonetize all series of all denominations on one day.
That if the government wants to
Because
come,
the word any is used twice.
that's how it is tested. I
Any
understand.
There is a choice or an option, only this particular denomination. But if you say any means all series of all denominations, all
That
notes.
is why the context is very important. Any one of the denominations where the government and the RBI will choose to decide for any one of them.
Yes.
That's right. That's how it must be read. I'm not saying any means all.
That is how you want to.
That's right. That's how it
Meaning
should
to
be
this.
read. Therefore, once that any one of them, a few of them, such of them, you can give that very flexible meaning. Once they decided, then what kind of series will necessarily be again connected to the decision on the denominations issue. You can have one series, you can have all series, you can have few series. Therefore, don't try to narrow down the meaning that can be given to a very important dynamic part of section 26.2. It must say, unless there is, suppose it's very difficult even to say the government would not apply its mind, RBI would not apply its mind to what kind of denomination, what kind of series. They're all within the knowledge and domain of both parties. So to enter into a discussion on some kind of external racial criteria or normative criteria, so you could have chosen 10 series, you could have chosen 5 series. Look at what happened thereafter. I don't think the court will ever get into it. There can be bankers' disagreement on that, experts will disagree. Finance ministers may disagree.
Yes.
But I don't think the court will enter it.
Ultimately, the choice is yours.
Yes.
This is what you want to suggest.
That's the choice is mine. Depending upon the
choice is
compulsions, the perseveration, the compulsion, the perseveration, and the felt need of the government and the RBI in doing what am I going to do, what I want to do.
Yes.
So will that area of perseverance and compulsions, which will be connected by a series of dots. The dots are within the knowledge of RBI and the government. Now the petitions want to say,
no, whether it is good or bad is a different aspect.
Yeah.
But you have the power under section 26.2. This is what you are suggesting.
That's right. That choice How do you, what the
Choice is yours.
choice? Yes, provided somebody will ask, then how do you have a choice? What is the criteria for a choice? My twofold submission on that. The choice will be certainly persuaded, will be by certain factors which come into the understanding of the government and the RBI. I mean, not called upon now to deal with a very major issue of reformation of a monetary policy. Black money sitting like this, fake currency, always a teasing illusion. What do I do? Therefore, I think, let me try this. Then the court will come and say, no, no, I'm sorry, your trial is bad. Your trial, I don't think a trial and error can be done like that. I think every day's national economy is a matter of trial and error. And Bloodfed knows about it. So therefore, I'm saying 26(2) must receive a dynamic interpretation. Let me proceed further.
But you can't say my learned friend knows it. We may have to cite him as a witness. All right, tell us.
What?
Yes.
In section 34, which Mr. Shyamdev read out, Lord, so kindly come to section 34. Then I'll straight away go to the ordinance and the act. The liabilities of the issue department shall be an amount equal to the total of the amount of the currency notes of the government of India and the bank notes at the time being in circulation. Therefore, the liabilities of the bank where are they? In this? Into the court. We'll also have this compilation of this relevant notifications ordinances. 46 and 78 Act. Very small.
We have, but then we have already marked in that comparison, so it will be more convenient to.
48, 78.
46 and 78 is not.
Anyway.
It is all post 1970. Yeah. Which makes it necessary to provide for the demonetization of certain high denomination banknotes. Exercise in powers conferred by Section 72 of the Government of India Act. So and so. The Governor General is pleased to make and promulgate the following ordinance. You can skip those definition provisions. Kindly come to Section 3. On the expiry of the 12th of January 1946, all high denomination banknotes shall, notwithstanding anything contained in Section 26 of the Reserve Bank of India Act, cease to be legal tender in payment or on account of any place in British India. Then prohibition of transfer, then exchange in 4, 5, all those provisions, 4, 5, 6, etc. I don't propose to deal them. There are dates fixed here, and then we have the 1978 Act, which is at page 18.
Yes.
In the 1946 Act, they talk about an emergency. Now they're talking about page 19, the preamble, an act to provide in the public interest for the demonetization of certain high denomination bank notes for matters connected so and so, whereas the availability of high denomination bank notes facilitates the illicit transfer of money for financing transaction. Look at the shift. in the focus of the understanding. So illicit transfer of money for financing transactions which are harmful to the national economy or which are for illegal purpose, therefore necessary in public interest to demonetize high denomination banknotes. Now look at section 3. On the expiry of the 16th day of so-and-so, all high denomination banknotes shall, notwithstanding anything contained in section 26, cease to be legal tender, parliamentary provision. So we're talking only about section 26. Now, as far as other provisions are concerned, they are more or less the same. Now, kindly come to page 3, the ordinance in question.
Ordinance in the present case.
Your Lordship. 8th of November 2016.
But Mr. Attorney General, one of their contention is you had made 2 acts. One is prior to 1940, what is that act?
46 Act.
46 Act.
1978.
Ordinance, all right, ordinance or act, what? And this time again act in 78. But why now under 26(2) notification? This is one of their question actually.
I'll answer that question. I'll definitely answer that question.
Yes.
Now that will be again a matter the court is asking me or somebody.
You can answer later, but please keep this in.
Exactly, I'll answer that question.
Yes.
I tried to apply my mind to it.
Yes,
Come back to it. Now, these are very important questions to be answered.
Yes.
The notification reads like this. I only want to say the shift, the focus is, and how the canvas has become little wider. Emergency 46, then public interest 1978. Now the enlargement of public interest. And the compulsions and the persuasions.
The compulsion is one. What they said was, because the government knew that that power is not there, these are enacted. Therefore, how suddenly the power comes into the act now for just issuing a notification is their contention.
The power is always there.
No, there should have been, right, that was there, why earlier it was issued is.
My submission, the power is always,
No, no, if the power is already there in 26(2), so it is an occupied field. If that is so, how can there be, because this act is of which year? This 1934 Act. In 1948, you bring an act. So was it without jurisdiction, that act? Or 78 Act? Because if you say it is an occupied field under 26(2).
A statutory occupation does not negate parliamentary plenary powers. A statutory occupation stands in a different footing.
Statute is also by Parliament only.
Parliament, no, that is a statutory provision. Under section 26, government will act, RBI will act. But the Parliament says, look here, notwithstanding whatever can be taken in 26, I want to enact a law. Therefore, the plenary powers of Parliament are always available to the Parliament. They are never impeded by a statute on hand. Therefore, whatever persuasion which Parliament then thought, why should I not go? Why government could have said, I'll go under 26. But Parliament said, I want to do emergency. Therefore, we are looking at now from a retrospective point of view.
See, 26(2) itself says by notification in the Gazette of India. Therefore, you can do it by notification, I suppose.
No, parliamentary legislation is also gazetted. That's a. I'm only.
Be by an act.
No, that's a small issue.
Next week, there is no sitting of this bench. We will fix it on next Monday. Because you have to finish earlier, you know why also.
I'm so sorry. I had to necessarily take this.
Otherwise, bench will be demonetized.
Next Monday.
There are 32 million people residing overseas. I hope your lordship will give me 5 minutes after the.
All right, sir. Let us see. So we will fix it on 5th, right? 5th. Mr. Chidambaram, 5th.
Lordship will take it up.
My lord, is 6th possible, my lord?
5th over 10:30. On 5th, Monday, on 5th of December
Very well.
at 10:30.
Very well.
On 5th,
Yes.
that's a Monday.
Monday, yes, Monday, because
Very well, I've noted. I'll try to adjust.
you know, we have some problem otherwise.
Very well.
This has to be finished. We have already started.
Very well.
There is no point in leaving it halfway.
Very well.
We will have it on 5th.
Sure.
List it again on 5th December 2022.
At 10:30.
10:30. भेज दो उसका रजिस्ट्रार को J1.
I am also appearing one of them.
Huh?
I am appearing for the intervention. I have a very classic case, my lord. I am losing my father-in-law and my client in everything. So I am not addressing it. So give me a 5-minute time and then.
All right. Let us see. Let the attorney complete. We will see later. Let us see. All right. Right.
Obliged.